What is the date in contempt? Who appears for the state? Mr. Chandrasekhar, you appear for the state, na? See, you filed an appeal, you are not getting the appeal listed. You filed an appeal, you are not getting the appeal listed. That's his. Just give the details to him. But we want to know who has filed it, who is the counsel who filed for the. We will have it after. Just take this contempt, ma'am. It's a fresh contempt. Just take it. Oh, this. Oh, you are moving the writ appeal. Just give the details to him. You are the respondent there. There is no date in the writ appeal. Just take it. Have it after 2-3 weeks. Yes, ma'am. What is the compliance seeking? What have you filed? What was the direction? Not demand? Okay. Take it, ma'am. Why you did not pay it? Then why the contempt? That's right. That's all right. Okay, but very well. Take it. Give it in July, ma'am. That's possible. Yes.
It's a fresh contempt, my lord. The Honorable Learned Single Judge has directed to pay the pension and settle all terminal benefits within a period of 2 months. But I am both, my lord, complainants are seriously ill, my lord. May I request
Take it,
next week, my lord?
We'll give you a date. Just take it. They have not done that. Is it a contempt? Huh? You're filing an appeal, objections removed. Contempt filed. Any contempt filed? Just take it, ma'am, after 2-3 weeks. We will give you a date, ma'am. We'll give our convenience date. Huh?
Subsequently, both we and the respondent filed our appeal. When we filed our appeals under Section 34, Section 34 court has allowed both the appeals, essentially nullifying each order. Therefore, I'm moving.
The other side has also filed. Okay, just take it, ma'am. Just 1 minute. We'll give you our date. There is no hurry. There is no execution. Which matter? Oh, you are also mentioning. You are the other party. Both take both. Objections removed. You exchange your appeals.
Lord, it's a writ appeal matter, my lords.
Ma'am, 1 day both.
It was dismissed for non-compliance of office objection, my lords. Lords, it was listed for 4 o'clock. Due to oversight, a senior couldn't appear, my lords, on that day. Lords, IF for recalling has been filed, my lords.
Take that, ma'am. Give it in July only.
Grateful, my lords.
The Karnataka Milk Federation, which affects dairy cooperative.
Karnataka?
Milk Federation. Declared as public authority by the Karnataka Information Commission.
Yes.
They have challenged it before the.
So you are challenging that?
No, the Milk Federation has challenged it before the High Court. Leonard Singleton has set aside the order of the Information Commission. So we have filed an appeal.
Who are you?
I'm a farmer actually. Farmer. Based on my complaint, they have been declared as public authority.
Okay. So yeah, just take that. Objections removed?
Yes, ma'am.
Give it in July, ma'am. What is the urgency? Your suit has been dismissed. We will see. Man, just take it. Give it convenient, ma'am. What similar matter? What is that? Oh? The signing. Yes, ma'am. Any mentioning? Take it, ma'am. Take it.
Your Lordship, may I make a submission, my Lordship?
Hours only, no? Huh? Give me convenient date, ma'am. There is nothing urgent on this. Okay, start the
Your
board.
Lordship, Your Lordship, may I make a submission, my Lordship?
Your Lordship,
Mr. Chinnappa, you just come. We'll have your matter first.
Your Lordship, seeking adjournments,
Yes.
Your Lordship. Serial number 88, seeking for a short accommodation, Your Lordship.
Just wait, Mr. Chinnappa. Want at 2:30? Only we can do only one.
You had requested.
We can do one. We have to get it before. We'll have it at 2:30.
Lordship, serial number 80.
Just 1 minute. We'll just run through the list. Just hold on.
Please.
Serial number 1,
Who appears?
Sri Rakesh Bhatt.
Huh?
Serial number 1,
Yes. You have to remove objections. Office objections be removed. Office objections be removed in 4 weeks. Next,
21-8,
office objections be removed in 8 weeks.
21-8, serial number 3. Serial number 3,
Serial number 2,
For
madam.
the appellant adjourn to. On office objection be removed in 8 weeks.
Madam, we are appealing for the.
Lordship, there is some
Oh
urgency.
no, this is the same matter. We are
Three.
all matter, batch matters, na?
Please, my lord.
These are batch matters. Yes,
Medical, the grace marks matter.
yes. Now,
Where-
what is the
Rounding
urgency,
off.
Mr. Reddy?
Please, my lord.
What is the other? Does it really require in a
Yes.
heard
It
today?
is urgent, my lord,
Except
because,
the fact that they are not eligible or they are eligible now.
correct, the one is the eligibility for future NET courses. Second is.
Who appears for NMC? What is your case?
Our case is, there are 2 rounds of the marking. First part of the marking is when every paper is assessed.
Use the mic. Ma'am, switch on the mic, ma'am. Both.
One of the first part is when every paper is assessed is assessed by 2 values. At that point of time, an average is taken and then it is rounded off to the nearest integer. Thereafter again, all the 4 papers are once again added, and then at that point of time, the mark that has been averaged off will have to be totaled. No further rounding off will be done. That will amount to 2 rounds of
That is
rounding.
that is a stage before you come to a conclusion how many marks they have scored. What we have understood, one should get 200 out of 400.
200 out of 400.
That's the 50%.
That is the 50. So there,
No.
what we,
Just one.
sorry,
Anyone getting 49 with decimal, how much 255075,
yes,
can it be rounded off? What the learned single judge said is 49.25 or 50 or 75 rounded off as 50%.
yes.
Is this permissible?
No, that is, so there, what we are trying to say is, there is no percentage in the second. There are 2 phases to this marking. First is the per paper out of the 4 paper marked by 2 values, which is averaged. That the regulation itself says shall be permitted to be rounded off.
Can you give an example?
What?
How would you,
Yes. For example,
the submission?
yes, my lord. For example, 50 plus 49 point or 2.
Let's take
2
2 papers.
Let's take 2 papers, two papers, 49.5 and 49.75. When we add the 2, it will come to 50.25, for example. So that will be rounded off to the nearest integer. So it will become 50. Where it is 49.75, when these 2 are added, it will become 50.
So what you are saying is,
That is the first phase.
Cumulatively, all papers should be 50 and above. Are we to understand you this way?
One more aspect.
Even though in one paper he is less than 50.
Yes, yes,
Right?
yes. And there is another dimension to this. Another dimension. Each paper should have 40% for marking, but that is not the subject matter here.
Not the issue.
That's not the issue here. So every time when the first average is done, there is a rounding off. But there will be no rounding because that mark will be taken as it is and then added off. That's why we have mentioned in the regulation, not a percentage. We said 200 out of 400 because for every quarter percentage point out of 400, it will actually mean a 1 point addition. So that is,
Understood is this,
yes,
when 49.25 and 49, let's assume what example you have given. It goes beyond 50.
yes,
That's right. But in a case, if it doesn't go beyond 50, but less than 50,
yes,
there is no rounding off
yes. There cannot be a rounding off because we are not taking percentages anymore.
in the second stage.
In the second stage,
Okay.
we are
Let's
taking
hear-
the mark as it is. If you've got 49 point, if you've got 50.5,
remains.
whatever, all those will be added.
That's, yes, Mr. Chinnam.
In fact, what we have just said is the entire arguments,
We got it.
virtually, except for the citation.
Except we'll see that regulation.
Yes. The issue is only this one. Every paper is subject to 2 valuations. Every paper is valued twice. That is 2 values valued, and the average of the 2 valuations are taken into consideration. Therefore, if one gets 49, my learned friend said 49.25, and another one has 49.75, the average will be 49.5.
That's right.
So that, my lord, for that subject will be rounded off to make it 50.
Now, is there any principle for rounding off?
Yes, my lord, there is. At the first stage,
Principle, there's a law.
no, the principle is there in the regulation itself, that the first stage of rounding off is permissible.
That's first.
So if you get 49.5 on an average, then it will get rounded off to 50 marks. It's marks, my lord. I'm not on percentage now. It's on marks. So if I get 49.25 in the first valuation, and the second value said 49.75, the cumulative score will be 49.5 between the two. 49.5 will get rounded off to 50.
But is it one paper or two papers?
4 papers.
No, let's give an example with regard to 4 papers.
No, 4. I'll come to that. First, every paper is valued twice by 2 separate valuers.
Okay.
So that's why you have 2 marks per paper.
That's right.
So those 2 marks get added, and you take the average of the 2 marks. Whatever is the average, that gets rounded off to the nearest percentage. Maybe 49.5 will become 49.50 itself. But once you add all the marks, then you have to reach 200.
That's 50%.
That is 50%. So in one subject you may have got 60, in another one 45.
Yeah.
But still you may hit 200. What they are saying is when you round off, when you accumulate everything and come to one particular mark, you may come to 197, 198 or 199. They then make it into percentages. Then they say I'm 49.25%, 49.5% and 49.75%. Now you round off the percentage to 50%. That can't be done. The second rounding off, that's the regulation.
The issue.
First round off is
Of marks.
acceptable.
Yes, that is acceptable.
But the second rounding off of the
When you
percentage-
add all the marks and then come to a grand total, that rounding off is not permissible. That not is the
So
entire
it's
issue.
only at the time of evaluation of the paper,
Paper.
answer paper by 2 evaluator, the rounding off is possible. The not rounding off, average of the marks between the two, because there can be a difference.
Yes,
in the
but if
marking.
it's 52, for instance, the average between the two will become 50. So you straight away pass. There's no difficulty. It is only in these scenarios where the difference in marks is so low, so close, that you come to a mark which is between 49 and 50, that you have to round it off. Otherwise, if it's 48, it is really of no significance, because anyway you fail. The second requirement is overall in one subject you may get 40, so the minimum is 40, but the total should be at least 50.
That's right, one should be 50.
50.
Now, does the regulation say,
Yes.
let's assume, in fact, we will ask them,
Yes.
anyone getting 49 in the
Yes.
second stage, after the marks have been averaged,
It actually says the contrary. It says no grace marks.
no grace.
No grace marks. Your Lordship may only see one thing in
Just show
Writ
it.
Appeal 448. That is, I think, serial number 4.
How many matters and contempt petitions are there?
Well, Lordship.
All are appearing in this. Mr. Reddy, you have been briefed in all matters, appeals?
Lord, I'm appearing in WA. Which one is it?
No,
4487.
if we have to take up, we want all the councils to be here.
Yes, WA 44. 3 respondents.
Here,
Lord.
there, Lordship.
3, 12 and
Or
11.
we'll do one thing, we'll have it next week. Let all the councils be there. Maybe Wednesday, Thursday, we'll have it.
Contesting respondents on
All
the
are
petitioner
there.
side, we are here. It's contempt petitioners as well as Malots, these two.
All of us are here.
All of us are here.
All of us are here. Or Monday it could be taken. Lord.
No, we'll have it on Thursday, Mr. Reddy.
This
Wednesday, coming Thursday, next week Thursday.
Thursday.
On this Thursday,
Can we ask for a shorter date? Lord? Only thing is, the future prospects gets.
next Tuesday is what? 24th and 25th make a difference, 25th make a difference, or 24th
The
make a
third round of
difference.
counseling, it appears,
Sing.
the third round of counseling is on June 27th. So for super specialty courses. So at least if it is
That we are
taken
not
on
qualified for,
Monday.
as a matter of
Okay. What do you say?
Now, Lord, so far as the supplementary examination is concerned, the marks I'm told have come. 6 of them have passed.
But they will be going for,
But
Are you saying with this, single judge order, 6 have only cleared?
I don't know.
No.
With a single judge order, everyone would have
Everyone
cleared.
gets
Yes,
cleared.
everyone is cleared.
So that's their
But they
anxiety.
also,
That's-
without prejudice, taken the supplementary examination. In the supplementary examination, out of the 25, only out of the 26, 6
Because they
have passed.
never issued the degree certificate.
So then, Mr. Chinnappa, we have heard you. then 6 in any case are entitled to be for the counseling.
No. Counseling, my lord, last cutoff date is April 30th. They should have qualified by April 30th. So they must succeed in this writ petition in order to qualify.
As a special case to be considered, because on the
For the
strength of the
6th.
order of the court.
Yes, yes.
No,
April 30th will still come.
will
They are
still
not
come.
contesting this.
No, April 30th will still
Because the
come
order came about in
because,
March.
my lord, if they succeed before your lordship,
Came about in March.
no, if they
This
succeed,
single judge's order,
Before 30th.
yes, before
Lordship,
30th.
I received it in February
no, if they
24.
Because the
succeed in the writ
university
appeal, my
delayed,
lord, if they
protracted.
succeed in the writ appeal, they become eligible for counseling.
Ah,
That is true. That goes without saying. If they succeed in the writ appeal, they
Read
become
the
eligible.
counseling.
Third round.
Third round, I don't know.
Third round is underway.
Third round is underway. When is the count?
Just
June.
ask them, just take the instructions.
June
23rd.
23rd.
23rd of June, I'm told is the third round.
It is the last day for counseling. I'm not, this position is covered by 2 division bench orders. At least 1 division bench order is clearly on the point, where the same argument that was set up by them was answered by the division bench. That the second round is not permissible.
These regulations are new, my lord.
Principal, my lord,
This is not answered. These are not answered. 23 regulations.
And
are
if
not
it is
considered.
covered by the
There are
division bench,
23 regulations. They have never been considered in the past. They're being considered for
it
the
is
first time.
paramateria same.
we do not fall under the
Language.
23 regulations, my lords, because we have been admitted under the old regulations.
No, no. The exams are conducted under the new regulations.
We fall under the old regulations. There are misconception, my lords, at the
What
university.
they
that
did,
we
Lord,
fall under the new regulations.
Interestingly, what they did regarding the 23 regulations was there were new regulations that they adopted.
Nowhere does the
What they did was, they took the pattern of examination from the 19 itself. They said, we will follow the same pattern of examination of 19, but we will not follow the new pattern of examination of 23. New pattern had various other nuances.
But that's not the issue now.
That's not the issue. But point is that they themselves have not followed the 23. For them to say that 23.
So, but that's not the issue.
That's not the
Is
issue.
only simply is
Yes.
on the.
No, it's there.
According to
they're
me,
relying
Lord-
on the 23 regulations provisions to say we are not entitled.
According to me, Lord, division bench covers this position.
We'll have it on Monday then.
Yes, please.
Re-notify Monday.
2:30, I think is better, Lord, so that we will have time to.
2:30. No, 2:30 we have that. We have kept another matter.
All right, then
Have it, let it come in the normal.
normal course, please.
Monday.
Monday, please. Oblige.
This objection comply again.
Just
And they
give
can
me the
comply
first-
the office objection.
See, we want only one thing. How would you ensure it? Every appellant or the contemptor who has filed it, they are before us. If we issue notice,
All of us are here, Lord.
All of us are.
we take it,
Yes.
all appellants
Three,
are being
I think,
represented.
Yes.
Despite
Three
them have not
councils.
having complied with here. my lords.
So it's primarily, Mr. Chinnappa, it's only this research, Medical Research Institute Center is one appellant, NMSC is one
The
appellant.
university is one appellant.
So all the appeals are between both of you.
Only
In fact,
yes.
all are yours only, except one by NMC.
That's,
All the others are mine.
Lordship,
We
I
take
appear,
it, all respondents are being represented.
please Lordship, I appear for major appellants Lordship, and I came with a caveat. All of us are.
Between
before
you
your
and the
Lordship.
council, other council, you appear for all the respondents.
there is no one unrepresented. There is no one unrepresented. Everybody is,
We want that.
yes,
Monday.
please.
Please.
Oblige.
What? Objections? Just say that re-notify on Monday. The,
Mention the serial numbers, they are scattered.
Yes, Lord, we'll give a list of all the serial numbers so it can come together.
Already given.
just give the briefing council. Mr. Chinnappa, you have to give
Lord,
us.
can it, is it
And
possible?
contempt petitions.
Yes. Lord, is it possible that it could be taken up on Friday, a chance, Lord, because Monday is the counseling.
You're right, there would be some difficulty. That's
Otherwise, there would be 1 year that they would have to wait. That's the difficulty. Friday, if we can,
Actually, we don't do counseling. Why you?
See, there is one specially directed matter from the Supreme Court that we have to hear it.
on Friday, Lord.
Not Friday, by 30th, today we want to hear it. And with the board being there and we have kept it, that's the reason.
Can we take a chance on Monday, Lord? We'll see if it is possible.
Monday,
Oh, sorry, on Friday. On Friday, if we can take a chance. If
Friday
suppose,
we have a difficulty, that's the reason, Mr. Reddy.
all
The
right,
bench will have a difficulty.
all right.
That's the reason.
There are split benches in the,
Morning we can do.
the issue is, Lord, 1 year we would lose. There's no. One chance on Friday, my lord.
You take a chance for Friday. We don't say
Yes,
anything.
we'll take a chance. That day, my lord, suppose it is heard, then at least 1 year chance.
No, Friday would be difficulty, Mr. Reddy.
Let it be posted, my lord. Let us see if your lordships find the time. Because 1 year would have to wait from Monday 23rd.
We'll hear it today.
Ah,
You be ready.
please.
We'll hear it today. That's the issue.
Yes.
We'll hear it today. Okay. You can
Please.
start, in fact. You people can start. Yes.
Please.
Just give us the serial numbers. That's enough. What are those? Now come, Mr. Channappa, you'll start.
Wait.
Now tell us the regulations.
Yes, the regulations.
For what?
Regulation.
This 488.
Where it says, kindly see para number.
What is the application? What is Rule 617? What is the application for?
That is for amendment. Amendment of the.
Why? What is the amendment you are seeking?
Please see page 16 of the. Where it is pointed out that the regulation itself states.
We have 6 pages.
No, this is the amendment application.
Just show us the petition, ma'am. Appeal. Which is your number? NMC, na?
Yes, my lord, the first one.
Item 3.
465.
Page 16.
My lord may see that 8.4B, last word, last sentence.
4.
8.4B, last word. My lord, that says nearest.
We are at page 16.
16, my lord.
Huh?
It says nearest integer.
5%, no. Thesis, vivace will be given quality. Are you reading the bracketed portion?
My lord may take para 7, which is now in page 17 of this. I had kept the amended petition, I'm sorry. Page 17. Page 15 is the extract. It starts from there. 8.4B. If my lord sees the second last.
All answer scripts shall be subject
Second
to
last line.
evaluation.
Second last line of
The average of the
8.4B. Second last line of 8.4B.
We are reading that.
Yes, at the end it says nearest integer, my lord, whole number.
Rounded off to the nearest integer.
Yes, the errors
shall
that
be
have.
the final computation.
Yes.
Of it. Let's read the whole sentence. Yeah?
Yes, my lord, the whole sentence. The average of the best two.
8.4B.
Yes.
All answer scripts shall be subject to 2 valuation by the concern. The average of total marks awarded by 2 evaluator for the paper, which is rounded off to the nearest integer whole number, shall be considered for computation of the result.
All the answer scripts where the difference between the two valuations is 15% and more, and the total marks prescribed for the paper shall be subject to third valuation. The average of the best 2 total marks awarded for the 3 evaluators for the paper, rounded off to the nearest integer. So the term used in the regulation is nearest integer.
So what is the amendment?
Then
you are
the
seeking?
amendment that even in the narration, kindly see, it has come in as on page 7, my lord. Page 7. It has come in as para 7, my lord. Third line. It has come in as next higher number, my lord, instead of nearest integer.
So this is the amendment you are seeking.
That is the amendment.
So
that likewise in para 12, para 13.
Next should be read as nearest.
Yes. Likewise also, no, 2 words. Next higher should be read as nearest. Likewise in para 13. Third line, para 13. Page 19. Second line from the bottom of the page.
Hmm. Next higher.
And in my narration itself, earlier, if my lord sees para 12, it is correctly mentioned. This is the second time where there was an error. In the sixth line, it says again correctly nearest integer.
Okay.
So in my narration also, I've used the correct one. In the regulation also correct, but in two paras, it has come in wrongly.
Why do we file an application?
Well,
We'll record your submission.
Well, I've got the amended also, so it will be convenient for the court.
Okay. We'll allow this application, Mr. Reddy. He is only seeking correction of this next higher must be read as nearest in terms of that regulation.
All right. In the body of the writ appeal, no? The
Body of the
pleading,
writ.
pleading, yes.
See, if you see page 17 of that appeal,
Yes. NMC appeal.
that's right. Come to 17.
17.
Page. Paragraph 7.
17. We have a different, taken a printout. Can you just show? Okay. Here it is. Yes.
Just say this.
To nearest integer.
Yes. Same thing is mentioned here.
This is an application filed
So
by
here, instead of that, it's next time.
the
So in the
counsel
narrative,
for the
again, in the
appellant
narrative, it is mentioned.
All right. So as per the regulations. Please.
seeking amendment in paragraph 7 and paragraph 7 and 13 of the appeal memo, wherein third line of those paragraphs, wherein the words next higher number is sought to be replaced by the word nearest. Full stop. Similarly, second line in paragraph 2 of the synopsis, a similar amendment has been sought. Full stop. Mr. Reddy Leonard, senior counsel appearing for some of the respondents in these appeals, has no objection if the amendment as sought is allowed. If that be so, the prayer as sought in the application is granted. What have you filed? The amendment?
And these are the amendment.
The amended appeal?
Amended.
The amended appeal has been, amended appeal has been filed. The same is taken on record.
I've already served them.
Let a copy of the same has been served on the counsel appearing for the respondents. Full stop. Application disposed of. Yes, come. Ma'am, this would be in item 3. The registry shall number the application. Just say that. Next, yes, come, Mr. Anand.
Can I?
So we have taken up which appeal, Mr.
Lordship, can I take writ appeal 440A, serial number 82? The papers are.
Serial number
completed.
82?
82.
Yes.
My lord, I'll just give you a few facts, my lord. So the PG exams were conducted in January and February 2025.
We are concerned with PG.
PG.
Which month?
January of 2025, January to February of 2025, 2,849 students appeared for the examination. 2,583 passed. So 265 failed, my lord. and 25 came to the High Court. 26 came to the High Court.
On the pass or failed.
Failed.
265 failed and 26 came to High Court.
Out of that.
Out of the failures, out of the 265 who failed, 26 came to the High Court. The difference in, this is where it's different, difference in marks is between 197 to 199, basically in theory examination. To pass, they have to secure 200 marks. The difference in marks ranges between 190, some students got 197, some got 198, some got 199. Therefore, the difference is, when you calculate as percentage wise, 49.25, 49.5 and 49.75. So they say that last bit has to be rounded off, which means not either addition of 1 mark, 2 marks or 3 marks. So some have got 197, therefore they are asking for 3 marks, 198, 2 marks, 199, 1 mark, to come to a magic figure of 200. That really is the issue. In my humble submission, that is really not rounding off, because you must hit the 200 figure. This, what they are requesting by virtue of this rounding off of a percentage, is really increase of 3, 2 or 1 marks. 1 second. Can I request Manoj to kindly come to page 95? Manoj? This is the regulations which the NMC has made.
190.
Page 95. May I just take your lordships to at page 95 is 29 December 23. In exercise of overall powers conferred by the NMC vis-a-vis medical education in general, and specifically by subsection 125, subsection so and so, makes the following regulations. Please see the focus and goal. The focus and goal of postgraduate medical education shall be to produce competent specialist and medical teachers recognized by the fraternity as the graduating scholars, building upon the undergraduate education and skills, who shall recognize health needs of community, carry out professional obligations. Basically, my lord, to ensure that they have students who have qualified well and passed the exams well. Therefore, there's a whole scheme as to how it must proceed. Several of the other provisions are not there. Your lordship may kindly come to 8 at page 96. Examinations. Medical college or institution will conduct the formative assessment, examination, and the university will conduct a summative assessment. Both formative and summative assessment shall consist of theory, clinical or practical, and viva voce. Lord, may kindly see examiners at 8.2. Examiner, both internal and external, for the postgraduate examination in broad and super specialty shall have 3 years experience as recognized postgraduate guide in the concerned subject. Minimum number of examiners for postgraduate education shall be 4, out of which at least 2 shall be external examiners, and at least one of them shall be from a different university outside the state. Examiner shall not be appointed for more than 2 consecutive regular examinations for the same institution. Then the methodology, there are broad specialties for MD, MS, there's a theory paper, and the clinical paper, my lord, at B. And the method, my lord, broadly is indicated as to how the student should be tested. Then, my lord, may kindly come straight away to 8.4 on the next page, valuation, which is really the crux, page 98. Valuation. All the teachers of the other colleges of the concerned university or other universities who are eligible to be postgraduate examiners can perform the valuation of the answer scripts. All the answer scripts shall be subjected for 2 valuations by the concerned university. The average of the total marks awarded by the 2 valuators of the paper, which is rounded off to the nearest integer, whole number, shall be considered for computation of the results. That is where it should end, really.
Now, if you can, now what we have understood is this. Now, what example you have given for, let's assume for a moment 49.25 and 49.75, average to 49.50. Now, this 49.50 will become 50?
In that marks, in that subject, yes.
In that subject. Now, what would be the minimum decimal, or like what I'm asking is, suppose the gentleman has 49.01.
It won't happen. There's no scenario of that kind.
No, hypothetically.
Then it should be 49.
Then it would be
Nearest integer.
Nearest integer means, now what we have understood is, if it is on the same principle, it may not happen, 50 may not happen there.
May not happen.
Even if it is 49.25, it will become 49.
Should become 49 because here they use the expression to the
Right,
nearest
so it will,
integer.
that's what we wanted to ask you. 49.25 will be 50 only. It's 49, 50.01 can become
50.
Yes, in any case it is 50. No, 49.50 can become 50.
50, certainly.
For that, where is the
There's no problem there. No. At that stage, there's no problem at all for anyone.
49.5?
Yes.
If you take it as a nearest integer, it is in the middle.
No, that is always considered as the higher, to the higher one.
Beyond, above 50.
Above 50.
Above 50.
No, it is above 49. So it will become
Above
50.
49.
Above 49, so it will become 50.
If it is 49.5,
Yes.
49.25, then it becomes 49.
Should become 49 to round off.
If in the below integer.
Below.
Below it.
1 minute.
Or 49.
Here, my lord, we are all at this stage. My colleague, my lord's concern is that I'm confusing percentage and marks.
No.
I'm
we
not
are on
confusing
marks.
percentage and marks. We're on marks only.
We are on marks.
Marks only.
They are only marks.
Marks.
49.4 will become 49.
Yes.
Because
49.6
Will become 50. 49.5 and above should become 50 mil. And I'll also point out in the marking that has been done, which we have now with us, everything is in 0.5 decimal. Therefore, the problem of it becoming the lower is not there at the stage of marks. Everyone lot has awarded 0.5. There's no 0.25 or 0.75 which is awarded. Everything has been 0.5 only.
But
So either in a particular answer, he gets 2 or 2.5 out of 3. I'm just saying. He's been given either 2 or 2.5. So that 0.5 has always remained 0.5. Therefore, this confusion of whether it will come to a lower figure will never arise. So the marks will always be to the higher figure. So, but between two valuers, if your lordships have one is 49, one is 50 and another is 49.5, then it comes to 49.75 marks. He'll immediately go to 50.
he'll go to
He'll go to 50. There's no difficulty there. We have the chart, but let's finish this. No, let's just finish this. Therefore, my lord, at that stage there is no difficulty. Everyone's marks gets rounded off to the higher integer. It's never to the lower integer, and there's no complaint from anyone that my marks have now been rounded off to the lower integer. It's always been rounded off to the higher integer. So between the two valuers, if the marks come as 49.5, he goes to 50. If it's 48.5, he gets 49. Because ultimately, my lord will see that you have to get overall 50%. Because I may get 70 in one and 40 in the other. But overall, I may be 55. In which event I have passed. But minimum is 40 in each subject, 50 overall. That's the requirement. Now, please see the next sentence, my lord. All the answer scripts where the difference between two valuations is 15% and more of the total marks prescribed for the paper shall be subjected to a third valuation. That's where there's a difference between two of them. One gives 50 and the other gives 60. So the difference is 15%. Average of the best two total marks awarded by 3 evaluators for the paper, rounded off to the nearest integer, whole number, shall be considered for final computation of results. Therefore, in this part, first is determination of each subject. So out of 4 subjects, you must get so much of marks. Minimum is 200, maximum is 400. Or after the computation and declaration of the results, under no circumstances revaluation is permitted. All health universities imparting postgraduate courses shall implement digital valuation criteria. My lord, may kindly see theory. Number of theory papers is 4. Marks for each theory paper is 100. Total marks of theory is 400. Passing minimum is 200 out of 400. 40% minimum in each paper. Practical is 300. Viva OC is 100. Passing again is 200. Candidate shall.
Why do you say passing minimum of for theory is 200 by 400?
Yes.
40% in each paper.
Each paper. So, my lord, as I said, in 4 papers, in the paper 1, I may get 40 marks.
That this is not something relatable to 200/400.
No, it's not relatable to 200. But overall, my marks when added should come to 200.
You should get 100 out of 400 to be
200 out of 400. To get 50%.
criteria is 40%.
Each of the
40 in
bids.
140.
If I may give an example.
140, another 60.
Ah.
Then it makes.
This 40 is not related to this 200.
No.
So, my lord, taking my lord's example, which I overheard, if I get in 2 papers 40 and in 2 papers 60, I've got 50% overall and 40% minimum each paper. So I've passed.
No, but this bracketed
Ah.
is not relatable to 200.
It's not related to 200.
That's what we want.
Yeah, that's true, my lord. It should have possibly come one line later. 40% minimum in each paper. Your lordship is right.
Yes.
Then, my lord, we'll see theory aggregate is 50%. There they say, in addition, in each theory paper, a candidate has to secure minimum of 40%. Practical or clinical and viva OC aggregate 50%. If any candidate fails and even under one head, he or she has to reappear for both theory and practical, clinical and viva OC examination. 5% of total marks of clinical or practical and viva OC, 20%, 20 marks will be of dissertation and thesis. That's not relevant, my lord, for this case. Then last one, no grace mark is permitted in postgraduate examination, either for theory or for practical. Now, the percentage is only a consequence of the marks. Therefore, the concept of rounding off of percentage is not considered anywhere in the regulations. The rounding off is only at one stage because it's already rounded off. Once it is rounded off, your total will be a round figure. Rounding off is not to give a benefit to a student, but only to determine the marks that he's entitled to. So there is no 0.5 marks in any of those scenarios. So whatever marks you get, if you get 39.5, you'll get 40. If you get 49.5, you'll get 50. 60.5, you'll get 61. Therefore, whichever way one looks at it, you get a total. The total you must hit 200 of all 4 papers. If it's unfortunate, someone may get 199, but that can't be helped. It's a consequence of every evaluation mechanism that someone gets 199, someone gets 198 or 197. Can't then be rounded off to say you must hit 200 and pass a particular student. If that is the case, then in every scenario, this situation will arise where a student says, I came so close, and if you take the percentage, it will always round off. If it's a 600 mark paper, it will come to something lower.
So what has been directed by the learner single judge is rounding off the percentage.
That is not even contemplated here. That results in 3, 2 or 1 grace marks. It's practically a grace mark because it's no longer rounding off, because it's already been rounded off once. Where's the question of rounding off again? So it will never be a scenario where it can be rounded off. It is always going to be a situation of grace marks. So you have to give them 3, 2 or 1 grace marks to round it off in a percentage mechanism. That is, my lord, the entirety of the regulation. That's really the issue in this case. What has happened, my lord, is there are some judgments of our court which have rounded off the percentage under the old regime. And that has been taken, my lord, and said, because there was a rounding off in the past, we must round it off again here. And you must really, in my respectful submission, this is virgin territory in the sense that this interpretation which has to be placed on these regulations is the first time. It's not been done in the past.
How would you distinguish?
I'll show you lots of those judgments. Please see in this, we have produced it right here itself. At page 102, my lord has the first judgment. Guru Prasad's case, which has been followed. Please see 3A at page 104. At that time, there were 5 evaluators, 4 evaluations. If there's a difference, then it goes to the 5th evaluator. Then the average is taken, and then a lot of particular marks is assigned. Please see point A at page 104. The digital valuations of the petition at nature C shows that 5 evaluators are not provided key answers, and therefore, in terms of judgment in case of Nishita, there is infirmity in the valuation process. Contention, the said judgment shall not be treated as a precedent, even if accepted would not come to the rescue of respondent university, since parity factors have not the precedent. However, at this length of time, it is not worthwhile to subject the theory papers for valuation afresh, and some equitable relief needs to be granted instead. Straight away, the court says it's equitable. As per the extant norms of the respondent university, for passing in the examination, student has to secure 50% in the theory in aggregate, 50% in practical plus viva OC. Petitioner secured 49.75 in theory and 70% in practical. Paragraph so and so. Average of the best 5 total marks of the paper awarded by 5 evaluators, which is rounded off to the nearest value, shall be considered for final evaluation of results. Since arithmetically, petitioner has secured 49.75, said figure has to be rounded off to the next whole, and that will be 50%. And therefore, in this case, it was allowed. Then, Lord, there are 2 or 3 others. What then? Also, my lord, this was at the time when
What do you say about this
This is there, no? It is there. It is really there in terms of the regulations which are there at that point in time. But I don't think any law has been laid down in this. In terms of, my lord, where today the regulations are very clear that it has to be marks.
The regulation doesn't say COVID considered a university.
It's not there in the order.
Division bench.
Then, my lord, there's one division bench judgment which I. Can I request my lord to kindly come to page 112? This was a division bench judgment where we challenged an order of a learned single judge. This was a COVID situation. May I request my lord to please see 122 here. Here, my lord, the university had taken a decision that because of the COVID scenario, we'll do a rounding off of percentages. We had taken a decision, and it's available. I'll show your lordship that decision as well. That during COVID, because of the COVID warriors didn't have time to prepare enough, therefore there was we permitted a rounding off of the percentage at the very last, from 49.25 to 50. Any marks above that was rounded off. So that, my lord, your lordship will kindly see, para 5 at page 120. I'm sorry, 119, Lord. In Golab Hussain, para 2 of that order, page 119. After service of notice, respondent university has entered appearance, submits that a policy decision has been taken by syndicate yesterday on 12/11/2020, whereunder the cases of the kind can be leniently considered as a one-time measure in view of an extraordinary situation created by COVID-19 pandemic and in the best interest of the students. In the above circumstances, the writ petition disposed of, directing the respondent to consider the claim of the petitioner under the new policy, award benefit thereof to him, subject to him complying eligibility condition. Then this was considered at para 5. Aforesaid order makes it very clear, counsel appearing to the university considered before learned single judge, that a policy decision has been taken by the syndicate on 12/11/2020 for rounding off the percentage.
Not marks.
Not marks, percentage. There was a decision taken by us. Benefit to the extent Dr. Golab Hussain, learned single judge based upon the syndicate resolution and the concession made by the council has allowed the writ petition. Order passed by learned single judge, para 6 to 9 is as follows. The order, my lord, is extracted.
The same order.
Same order. Then at para 6, 122, meaning thereby, in respect of examinations which took place during COVID period, as the doctors were on active COVID duty, benefit of rounding off the percentage was given to Guru Prasad and MD Golab Hussain. And then at para 8, the COVID situation is considered by the court. Court has carefully gone through the forced judgment. It was a case of awarding of grace marks to a student undergoing postgraduate course. No such contingency is involved in the present case. Was involved.
Page 124, last 5 lines.
Yes, correct. This court is dealing with the situation. Almost the entire country is under lockdown. Even students who are doing under postgraduate, are the frontline workers, are practically doing COVID duties round the clock. Large number of doctors have lost their lives, and then the court says, I will not interfere with that order of the learned single judge.
Okay.
Then another judgment. Here, my lord, again in 22, page 132. What last 10 lines from bottom. After consideration of submissions at the bar, 132, my lord.
This is a review petition.
This is a review petition because
arising from
that order, my lord.
There the petitioner has scored 198 marks, lordship, and court has rounded it off to 50%. And against that order, university has filed the review.
Filed review was rejected.
No, where is the single judge order, original order?
That's not here, but yeah. That's not here. But there's another division bench judgment which I want to. This is Harun Adoni. Harun Adoni. My learned friend appeared in all these cases, so she knows.
Yes.
My lord, may kindly see para 4. Second submission done at panel counsel appearing for university. Subject provision of the ordinance in question provides for rounding off of the marks to the nearest full value only as a one-time measure is not supported by the text and language of said provision. There is nothing indicative of such an intent. University in support of such a stand cannot much bank upon the corrigendum dated 17/11/2020 issued by the Vice Chancellor, which mentions the COVID-19 pandemic situation. This is what, my lord, I pointed out to your lordship. Then the court says that the ordinance still continues. And since the ordinance still continues, therefore you must give the benefit of rounding off. That's the sum and substance of what they've said. But today, my lord, there are new regulations. And therefore these regulations have to be...
No, the regulation 8 you read.
I beg your pardon, my lord?
Regulation 8 you read, 8.4.
Yes.
Is post all these orders.
Post all this. Post all of this. This is 2nd November 23, which was really under the old regulations. This is December 23, my lord, the new regulations.
Yes.
I want to give you two judgments of the Supreme Court. No? There's my copy. Court of. On this whole question of this rounding off was actually considered not by the Supreme Court in Tania Malik. Can I request Malord to kindly come to one paragraph, para 22, at page 149. Para 22 at page 149. With regard to question as to rounding off of the marks, in our opinion, when a particular aggregate is prescribed for eligibility, a person must meet the criteria without relaxation. It is not permissible to enhance the marks by rounding off method to make up the minimum aggregate. This court in Rajiv Gandhi versus G. Hemalata held as impermissible the rounding off of eligibility criteria in relation to qualifying examination for admission to the PG course in MSc Nursing. Relying upon the decision rendered in Orissa Public Service Commission, this court observed, in Orissa Public Service, in somewhat similar fact scenario, considered whether the eligibility criteria could be relaxed by the method of rounding off. OPSC published an advertisement inviting application suitable candidates. That paragraph is there. And last line, she received the mark sheet. She realized she had secured 337 marks out of 750, 44.93 in the aggregate, and more than 33% of each marks in each subject. As per Rule 24 of the Orissa Superior Judicial Service and Orissa Judicial Service rules, candidates who have secured not less than 45% of the marks in aggregate and not less than minimum of 30% of each paper shall be called for viva voce. Since the first respondent had secured 44.93 marks in aggregate, she was not called for interview. The first respondent approached the Orissa High Court. High Court allowed the writ petition. Appeal from the state order was carried to this court. After considering the Orissa rules, this court in Rupashri Chowdhury held that 24 made it clear, in order to qualify in the written examination, a candidate has to obtain minimum of 33 in each of the papers and not less than 45% of the aggregate in all written papers. This court observed that when emphasis is given in the rule itself to the minimum marks to be obtained, there can be no relaxation or rounding off. It was observed that no power was provided in the statute or rules permitting any such rounding off or giving grace marks. It was clarified, Orissa rules are statutory in nature and no dilution or amendment to such rules is permissible or possible by adding some words to the said statutory rules for giving the benefit of rounding off or relaxation. In our opinion, the ratio of this judgment is clearly applicable to the facts of the case. Judgment of the division bench of the Allahabad High Court in Vani Tripathi was so and so, and the judgment of the full bench of Punjab and Haryana was cited before us because they take the same view. However, in view of the authoritative pronouncement of this court in Orissa Public Service Commission, it is not necessary for us to discuss the above said decisions. No provision of any statute or any rules framed thereunder have been shown to us which permits rounding off of eligibility criteria prescribed in the qualifying examination. for admission to the PG course and MSc, when the eligibility criteria is prescribed in a qualifying examination, it must be strictly adhered to. Any dilution or tampering with it will work injustice on other candidates. The division bench of the High Court erred in holding the single judge was right in rounding off 54.71 to 55 so as to make respondent number 1 eligible for admission to the PG course. Such rounding off is impermissible. Thus, the principle of rounding off method could not be applied in view of the requirement to obtain minimum aggregate marks to be called for interview in this case.
Okay. That's all?
That's
Yes.
As I said, that was virtually the argument. When my lord asked the question at the outset, I said that was virtually the argument. So that is virtually the argument, has been emphasized again. And I'll just make 3 or 4 one-line submissions, my lord. One is with regard to what the learned judge has said in the impugn order. The learned judge presumes that there is a mathematical principle which applies my lord has page 68 of
Excuse me, 5 minutes.
Come to 66 bottom.
please. It is submitted that the petitioner students are admitted to the PG course for the academic year 21-22 and the academic session has commenced in February 2022 post-COVID pandemic, and the petitioner students cannot seek parity benefits extended with the PG students in the decisions placed reliance by the petitioners. It is submitted that the petitioners are not entitled for grace marks as the petitioners failed to secure minimum marks to enable them to pass the examination. Having heard the learned counsel for the parties, the question that arises for consideration is whether rounding off at a percentage level would be akin to providing grace marks, and whether the benefit of the order passed in Dr. Guru Prasad's case and other similarly placed petitioners would be applicable to the petitioners as well. The petitioners are postgraduate medical students having failed by a fraction of percentage, as stated supra, are knocking at the doors of this court inter alia, contending that the said fraction ought to have been rounded off to the next whole number, which would resultantly pass the petitioners. Under the PGMR 23 regulations, regulation 8.4 stipulates that a student should secure a minimum of 40% in each paper and an aggregate of 50% in theory paper, and to secure minimum total marks of 200 out of 400 for theory and practical plus viva 200 out of 400. It is noticed by this court that the marks obtained by the petitioners when turned into percentage is arriving at 49.75, 49.50 and 49.25. The situation being such that though the petitioners have obtained 197, 198 and 199 out of 200 in theory, the percentage which is arrived at is in decimal. In the case of this, the percentage which is arrived at is in decimal. That is a statement and an exercise done by the learned single judge, which is not called for. In the case of Dr. Guru Prasad stated supra, though the decision was rendered during COVID pandemic, the ordinance dated 29/3/2019 was permitted to round off to the next full figure. And this court in Dr. Guru Prasad's case did not take into account the COVID-19 pandemic. But what was considered by this court is the arithmetical calculation. The regulations which were later changed in the year 2020 have now been withdrawn. It is contended by the respondent RGHS that rounding off would be akin to granting grace marks. The rounding off a percentage is a matter of arithmetical calculation. This is the area which I wish to read is a matter of arithmetical calculation. Up to here, it is a statement by the learned single judge of what we might have learnt in school, and not equivalent to granting of grace marks. The PGMR regulation does not explicitly prohibit rounding of decimal values in percentage calculation. But the PGMR regulation did not even stipulate percentage calculation for the purpose of passing. Then, the percentage to be rounded off to the next whole number is a part of a standard mathematical practice. Now, this phrase, and then the next line, and then I'll make my submission on the point. The petitioners who have obtained point percentage, the standard arithmetical rule dictates rounding off to 50%, which is a mathematical adjustment. Well, there is no such thing as a standard mathematical adjustment. Were it be so, in the Olympics, they would say that if you have reached there in a fraction of a second, then that will be rounded off, and that would render the entire games OTOs. Therefore, that cannot be. If you have a bank balance which says 0.50 paise, that 0.50 paise has to be put there in the statement by the bank. Therefore, there's no such thing as a standard mathematical practice. In school, we were taught that yes, when it is 0.5, it gets rounded off to the next. And that indeed has been practiced where percentage has been stipulated, and therefore it can be used. In fact, knowledge at the highest level, as has been held in a plethora of judgments of the Supreme Court, which my lords are aware, and we need not even repeat those, for the purpose of postgraduate education, has to be merit-based. And if we are talking about merit-based, we are not talking about the first mile or the mid-mile. We are talking about the last mile for merit. And for that purpose, if we are talking about, we are now looking at super specialists in the making, possibly in the making, sympathetically in the making, or in whatever way in the making, requesting to be made. For that, the only thing that we need to remember is we have had precedents in our past which says that if you did not know just one part of the Chakravyuh, you could not even come out of it, and that would be fatal. Now, if we are looking at that one part which would be about maybe 10-20% of the knowledge or the full knowledge, and here we are talking about a stipulated fact that at least you should know half of it. At least you should know half of what has been taught. And there also, if it is sought to be 1 mark, half mark. Now, who is to decide on this 1 mark, half mark, and why the 1 mark, half mark? Repeat the paper, cross the hurdle. If you cannot cross the hurdles in the hurdle race, learn more, practice more, you will jump over the hurdle. It's only 0.5, 0.25, whatever it may be. But if that is sought to be assisted, that is not permitted in the games either, in any fair game either. Therefore, it is our respectful submission for this purpose that where we are talking about PG to further super specialization, no push is warranted, my lord. No, that's about all. I have also extracted this judgment which my learned friend has read, and in the last paragraph, my lord, of my amended appeal memo itself at para 33, my lord, where the entire extract is there. I need not repeat that. They emphasize the distinction that was made by the learned single judge who discarded this judgment by saying, no, it is in the context of recruitment. No, it is not in the context of recruitment. It says where a certain rule has been, a certain rule stipulates in a particular fashion, then that holds good. That's the principle. That's the ratio. The ratio is not where it was applied. Don't say that it is because it is an examination here, that rule will not be applicable here. That is not the way to deal with it.
Okay.
And then, my lord, I had requested my learned friend of the university, because they are what we call our foot soldiers, and we give the guidance, my lord, so to speak.
Do that.
My lord, this is a statement which will give an indication to the court of the very first statement that my lord had made. I'll pass.
Just leave that.
My lord, this is how the calculation actually transpires. My learned friend has put in the effort to make this, but it was necessary for me to point this out because, and that is exactly what my lord had. My lord may see that V1 and V2 are the two valuators, my lord, the first two valuators for an individual value. And each set of column represents one paper. Therefore, the dark patch, up till that dark patch represents one paper. Then again, similar size for all the four. Each one will, if I may demonstrate from the very first one, my lord, if you take the first petitioner, we see V1 represents in WP 5830, 38 and 55.
Two
and
papers.
Two papers. V1, no, paper one paper, but
Paper
two
one,
valuators.
paper two.
Submit column of 4 papers. Total 4 papers are there.
Where is the fourth one?
My lord, yeah.
2, 3, 4.
My lord, we'll have to mark.
Theory paper 1, theory paper 2.
Okay.
Sorry, my lord, print file. It's become dark. My apologies.
every time V1 appears, that represents a separate paper.
So it has been 46.5 in theory 1, rounded up to 47.
Yes, so already there is a benefit of 0.5 accrued to the petitioner for no effort.
In that, in the evaluation, now how many evaluators were there?
2. 3 because 3 only in that case. In several others, it's not there. Where there's a 15% difference between 2 evaluators.
V1, V2?
Valuator 1, valuator.
Valuator. Why a third valuator there?
There's difference of 15% or more.
Oh,
Between
acha,
2.
okay,
So there's an automatic third valuation.
and the best of 2 would be taken in that situation.
Average of 2. Average of best of 2.
Best of 2. Okay. So what you are saying is this chart is only to say that they got the benefit of
At least
rounding off
once.
once.
That's in fact twice, Melats, not once. When they do the average, Melats, for example, Melats, the V1 has given
38.
38. No, I will not take that. That's number 3, serial number 3, Melats.
He has given 38.
Please, Melats, not that, Melats, just below that. One more. 49.5 has become 50.
Hmm.
Again, V2
So
has
actually-
given 39. So the average of 50 and 39 is 44.5.
Which one you are reading?
45.
Third one you are reading.
Third one.
Please.
49.5 became 50. Then 39.
39. The average of 39 and 50 has become
Yeah,
49,
44.5.
So,
You rounded off to 45.
so they've got it
Mark.
twice.
Then again,
Though that is not really mentioned in the regulation and not really permitted, but the foot soldier has gone a little further. We don't really mind that. We are not making an issue of it either.
But in any case, she achieved 40% marks
40%. But
in that paper.
please.
So half a mark there, half a mark again in the second round. So 1 mark already they have benefited. So if you subtract that 1 mark, then where does it go? It goes
Ultimately, your case is it's only the marks which need to be rounded off at the first stage. At the second stage, there is no rounding off.
So and it's not that we are inimical to them. By virtue of these 2 rounding off, we have shown that the grace is there. Though grace marks are not there, grace is there. And indeed, this grace reflects grace marks also because 0.5, 0.5. So it becomes 1 mark. Therefore, after that, once again seeking munificence, then it becomes, my lord. That is not permitted.
Okay. Yes, Mr. Reddy.
Yes. But your lordships are aware that while interpreting the provisions of the statutes, the division bench came to a conclusion that rounding off is permissible. No, my lord, since we have tread on the positions of law. What circumstance here we find is that RGUHS, that is the University in Appeal, has suffered this order of rounding off at the second stage in a chain of litigations before Karnataka High Court. And this is not the first case where they're in appeal. A number of cases, all cases. And the same arguments were set up in all the cases where single judges, benches and division benches have come down and said, no rounding off is permissible vis-a-vis the regulations of statutes of the university. And that, my lord, is 4 judgments on that point. Guru Prasad's judgment. I don't need to read all those judgments. This is position of law laid down. Haruni's judgment. Ghulam Haruni. And Adoni. Arun Adoni. And Nagadeviya's judgment. Now, my lord, I would just take your lordship to the pronouncement in Arun's judgment, Aruni's judgment, Adoni's judgment, sorry. which in the compilation of judgments that I am producing.
Yatish.
Page 42. Not 42. Yes, 42 by the single judge, Dr. Arun Adoni. Kindly see para 17, page 51. The single judge, where the second round of rounding off was noted. Under these circumstances, para 7.
Which para 7?
17, Lord. Single judge. Para materia circumstances, Lord, which ultimately went before the division bench.
Yes.
Under these circumstances, two judgments relied on by the learned counsel for petitioner are clearly applicable to the case on hand. Marks obtained by the petitioner in paper 1 at 51.25 and paper 2 at 45.25 requires to be rounded off to 52 and 46 respectively. Thereby, the total average marks would be 199 out of 400 instead of 197. Then petitioner would get an average marks of 49.75, which requires to be rounded off to 50% since the value as held by this court in review petition. So, the golden rule of interpretation to be adopted, keeping in view the object of beneficial legislation always in favor of students. This was allowed. Writ petition is allowed. Writ of mandamus is issued directing the respondent university to round off the marks obtained by the petitioner in paper 1 at 51.25 to 52 and paper 2 at 45.25 to 46 in the examination of discipline of MD pathology conducted on November 22nd with further to round off the total percentage to 199 instead of 197 out of 400 secured by the petitioner, then in total average marks of 49.75 to 50. Now, Lord, the parties that I represent, all of them have 49.75, have secured 199 marks. That is in writ appeal number, serial number 3, 11 and 12 in writ appeal filed by the university. In writ appeal 448. On facts.
Writ appeal?
Writ appeal 448 of 2025. Respondents 3, 11 and 12.
How much they have secured?
49.75. And there are other respondents also who have secured 49.75. Grounds at least 49 and 30.
Yes.
Yes. Therefore, now the position as it would stand is this judgment was taken in appeal to the division bench. And the very same set of arguments were replaced there. Page 54, very next page. Whatever is being argued now, including the Hemalata's case of the Supreme Court, was brought down as a proposition of law, was argued as a proposition of law. Here, Lord, kindly see para 3, page 56 of that compilation.
Mm-hmm. Yes.
Having heard the learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned single judge. Clause 4 of the subject ordinance reads as. So therefore, not the ordinance is reproduced. Text of the above provision in unmistakable terms provides, now Lord, for a moment, Lord, what I would bring before your lordships is this clause 4 regarding first round of rounding off is parameteria the same in the 2023 notification. There is no difference at all regarding the valuations. So, text of the above provision in unmistakable terms provides for marks being rounded off to the nearest value for the purpose of computation results of the candidate concerned. Second submission of the learned counsel appearing for the university that the subject provision of the ordinance in question provides for rounding off of the marks to the nearest value only as one-time measure is not supported by the text and language of the said provision, there is nothing indicative of such an intent. The university, in support of such a stand, cannot much bank upon the corrigendum dated 17/11/20 issued by the Vice Chancellor, which mentions that COVID-19 pandemic situation in support thereof. Relevant part of the corrigendum is reproduced below. The reasons for the corrigendum not coming to the aid, that corrigendum, where they said it is one-time measure. The reasons for this corrigendum not coming to the aid of the university are not far to seek. Firstly, the text of the ordinance as such has not been changed pursuant to this corrigendum per se. It is only in the nature of a recommendation yet to be expressed in the form of amendment to the ordinance. Secondly, Section 35 of the Karnataka Rajiv Gandhi University Health Sciences Act gives power to the syndicate of the university to make ordinances and to appeal or repeal the same is true. However, subsection 4 of this provision requires the same to be submitted to the Chancellor and the Senate for information as a sine qua non for its taking effect. The copies of the corrigendum are marked to the members of the syndicate, the Vice Chancellor, so and so, and deputy registrars. Marking of the Chancellor to the Chancellor is conspicuously lacking. This apart, the said subsection requires a date to be specified by the syndicate with effect from which the amendment to the ordinance would come into force. Such a date is not forthcoming from the corrigendum. There is yet another finer aspect to the matter. Chapter 5 of the 1994 Act provides for making of statutes, ordinances, and rules. Section 35 has already mentioned about delegates ordinance, making power of the syndicate. In exercise of the said power, syndicate has promulgated subject ordinance by notification dated 29/3/19. It hardly needs to be stated that such an ordinance is a piece of delegated legislation or subordinate legislation. Its provisions need to be construed as far as possible with the aid of principles of interpretation as are applicable to parent legislation, subject to all just exceptions. The text of clause 4, which is parameterium, the same lot as it is now, of the ordinance in question, makes it repetitive in operation, and that the same does not commit a legal suicide once the COVID-19 pandemic withers away. Therefore, Lord, that clause 4 applies irrespective of the COVID-19. It was not made for COVID-19. It hardly needs to state that the law ceases to exist by vicissitude. It continues on the statute book till repealed by the competent body in accordance with the prescribed procedure or is struck down by a court of competent jurisdiction. Such an ordinance has been made for the benefit of the student community. Relief to the deserving candidate cannot be denied by placing interpretation of the kind as university wants this court to place on the clause in question. An argument to the contrary offends not only the language of the provisions but also defeats its very intent. The reliance of the panel counsel for the university on the decision of the apex court in Hemalata does not come to his aid even in the least. Subject matter of this decision did not involve the ordinance in question. Obvious the same having been promulgated years before the said decision was rendered. The rules which were examined in the said decision did not permit any such rounding off or giving grace marks, unlike the subject ordinance in question. It hardly needs to be stated that a decision is an authority for the proposition that has been laid down in a given set of facts, actual or assumed, and not for all that which follows and which has been so laid down in Quinn versus Leather. In the above section, appeal is devoid of merits. Therefore, Lord, if we look at this clause 4 provision, and if we look at the new regulations of 2023, kindly see, if we juxtapose each of them, it is practically the same. That you may, your lordships may see at page 98 of the writ. So, what is being interpreted, kindly see page 100. Page 100 of the writ appeal at clause 4, procedure for valuation. At the bottom, B. Page 100, clause 4, B, Lord. The very clause 4 which was interpreted by the division bench. Yes. Now, Lord, at 4B, fourth line from the bottom, average of the total marks awarded by the two evaluators for the paper, which is rounded off to the nearest value, shall be considered for computation of result.
So what does that mean?
That means that what the two evaluators intersay on a subject, they decide, that will be rounded off. That will be added and then
that will
average.
be rounded off and will be used for the computation of final result.
Will be used for the computation of final result. Now, Lord, this was interpreted to mean two things by the division bench. One, the final part also there was an entitlement for rounding off in the final part also by this provision. That is how the division bench interpreted
How?
this. That is the interpretation placed by the division bench.
How?
By adopting the golden rule that this is for the benefit of students, one. Second, because there is no prohibition for granting grace marks. This was how they brought this principle. How they enunciated this principle, Lord, was that
Which para is that, Mr. Reddy?
that, Lord, the division bench. Kindly see the division bench. Sorry, division bench. 57. Para 5.
Is not supported. Para 4 text in the language of the set. There is nothing indicative of such intent.
The second submission of the panel counsel appearing for the university, subject provision of the ordinance in question provides for rounding off the marks to the nearest value only as a one-time measure, is not supported by the text and language of the provision. There is nothing indicative of such an incident. University in support of such a stand cannot much bank upon the corrigendum dated so and so. The relevant part of the corrigendum is produced. The reasons for this corrigendum not forthcoming, the aid of the university are not far to seek. Firstly, the text of the ordinance as such has not been changed pursuant to the corrigendum. It is only in the nature of a recommendation yet to be expressed in the form of an amendment. Secondly, section 35 gives power, that is the intimation to the university. This apart, the said subsection requires a date to be specified by the syndicate with effect from which the amendment to the ordinance would come into force. Such date is not come into force coming from the corrigendum. And then Lord Court interprets it on the basis of, therefore Lord, the division bench proceeded that once rounding off was permissible at the first stage, it was permissible at the final stage. That was how the division bench. Therefore, this judgment stares at the face of the university today. Now, Lord, in the single bench, okay, page 49 previously, para 16. Learned counsel for the petition also relies on the judgment of this court in review petition arising out of WP 17479 of 21, wherein under similar circumstances held as follows. Technically speaking, by the word of the notification, the argument of the learned counsel of the petition university that the percentage has to be rounded off to the nearest value can be interpreted as rounding off of 50.25 to 50, since 50 is nearer than 51. However, the golden rule of interpretation is that interpretation of provision should be made in such a manner, especially in such cases, keeping in view the objective of the beneficial legislation. The marks legitimately obtained by a student cannot be taken away. Out of 400 marks, the respondent student has obtained 201. While reducing the total marks obtained for 400 to 100, the arithmetical value would be 50.25. But this court is one with the student when it is contended that 0.25 is also the marks legitimately obtained by the student. At any rate, same cannot be taken. Therefore, although it is provided in the notification that while arriving at an average and rounding off the marks shall be rounded off to the nearest value. However, 0.25 cannot be reduced to the value which is lesser. This court is of the considered opinion that while interpreting the said provision, due regard has to be given to the intention of the legislature. It cannot be denied. Notification was issued for the benefit of students. Therefore, when interpreting the said provision, due regard has to be given to the objective, and therefore the view favoring the student should be leaned towards. Now, Lord, for a moment, what I am placing before your lordships is the propositions. One is that this position of law, the university has suffered by a judgment of a considered judgment of a division bench. But what I would stress further is the interpretation of pre-2023 clause 4 and the present clause regarding rounding off is the same. Paramateria, the same wordings. There is no difference there. That your lordships will get at page 98. Clause 4 pre-2023 was interpreted to say that rounding off is permissible. Now, my lord, kindly see page 98, which is post 2023. At 98, my lord, 8.4. There again, my lord, your lordships would remember there at clause 4 there was A and B. Same B, last 2 lines may be seen. The last 3 lines. The average of the best 2 total marks awarded by the 3 evaluators for the paper, rounded off to the nearest integer whole number, shall be considered for final computation of the results. Therefore, there it was rounded off to the whole number. Here it is rounded off to the nearest integer, but which makes no difference. Ultimately, the effect of both the words in that sentence or in that paragraph, the effect would be absolutely the same. Therefore, the division bench judgment said COVID-19, which they are trying to impress upon after Guru Prasad's judgment, pre-COVID-19. Then the university came up with a resolution saying, no, for COVID-19, we will interpret this judgment. Then they wanted to depart from that procedure. They said, no, COVID-19 is over, but the division bench said, in both positions, pre-COVID-19 or post-COVID-19, the ordinance governs. This ordinance is not changed. Therefore, you will have to hold on to the rule. And this was interpreted. In effect, the division bench said, when it is permissible in the first round, in effect, it is permissible in the second round. That is how the division bench interpreted in clear terms. Of course, it is not so explicitly stated, my lord. It's not so explicit, but the interpretation was such. Therefore, my lord, on this position, the previous division bench judgment binds this honorable court. And therefore, these students are eligible to be granted. This is number 1. Second, my lord, the second limb of argument would be for a moment, Lord, I would just take your lordships to one of the students here. Which respondent is this? Which respondent? R4. Now, Lord, out of the 3 students whom I represent who have got 199, kindly just see this, Lord. How the 2 evaluators have valued this. Of course, it is not exactly within the scope, but just to see the hard realities of how the university evaluates papers. Because, my lord, when we see the ground situation only, we can assess the injustice to the candidates. Here, my lord, kindly see that first paper. This is 8283 General Surgery 3. Lord, your lordships had that. The first evaluator gives 5 marks uniformly for all the 10 questions. Second evaluator gives 55. Now, Lord, here the situation I'm in is that it doesn't go to a third evaluator if it is not less than 15, and there is no revaluation. Therefore, I'm stuck with these marks. This is locked for me. But kindly see, how could a evaluator, the evaluator 1, give 5 marks uniform for all questions? Even an objective assessment of paper, there has to be some justice or rationality. This is how the university is doing its valuations. Now, kindly see the second person. At question number 8, second person, I get 0 for question number 8. Second evaluator gives me 4 for the same answer. So there is so much of variation or so much of injustice in how they evaluate papers. That is why this comes in as some sort of a justice for these students.
You see the next one.
Yes.
You mean to say that selection of evaluators itself is wrong? Then I think That is not subject matter here.
I'm not saying.
Different
No,
forums.
that I cannot enter that area at all.
The
That plot, I'm out of it.
quality of the evaluators, etc.,
Yes,
etc.
yes.
This is an effort
Yes.
to rectify that task.
Yeah, of course. In this writ petition and writ appeal proceedings, we cannot touch that.
But you see the
So
next
if
one.
you say so, then we may have to increase the threshold of 200 to 300.
No, my lord. What will happen is,
What will happen is only the finest will come.
correct. No,
And finest will enter the teaching profession.
no,
there
no, no.
also.
The finest, no. Other thing is, if the valuator is a little negligent, the finest may also
You're
find
right.
injustice.
But you see the third one, Mr. Reddy.
Yes, my lord.
The same valuator,
Yes,
see, as against first, he gave 6,
yes.
the second one gave 1. Now,
Third
where
one
will
is
you
it.
draw distinction between both of them?
Correct.
So it's just the satisfaction of the
Yes,
valuator,
yes, yes.
how he assesses the answer.
No, general medicine 4, the paper is different. Papers.
Right.
Yes,
Paper is different,
Yes.
valuators are same.
correct.
No,
Valuators are
Still, there is a
two
discrepancy.
different valuators, two different valuators. So what happens here is, what I was pointing out was, a valuator could not say 5 for all. That means there's no application of mind. In any case, we are not on that thing. But what the broader issues of the injustice to the students is what I'm bringing up. Now, Lord, this is one. The second thing is, in the judgment of Mridul Dar, Supreme Court has held. Yes. In that compilation, Lord, compilation of judgments, kindly see the last judgment. It is not that this is a Bombay High Court judgment, page 67. I'm sorry, page 68. ಇದೆಯಲ್ಲ? Bombay High Court. 62, sorry, 62. Sorry, 62. The learned counsel for the petitioner, para 6, Lord, placed reliance on the decision of the Supreme Court in the case of State of UP and another versus Pavan Kumar Tiwari and others, 2005 to SEC 10, wherein 3-judge bench of the Supreme Court presided over by the Chief Justice of India held that we do not find any fault with any of the 2 reasonings adopted by the High Court. The rule of rounding off based on logic. Now, Lord, this is a 3-judge bench of the Supreme Court, unlike what my learned friend was referring to, which was a 2-judge bench. The rule of rounding off is based on logic and common sense. Is if part is 1/2 or more, its value shall be increased to 1, and if part is less than half, then its value shall be ignored. 46.0 should have been rounded off to 47 and not 46, as has been done. If 47 candidates would have been considered for selection in the general category, the respondent was sure to find a place in the list of selected meritorious candidates and hence entitled to appointment. Mr. Samdel and the government pleader submitted that the petitioner did not possess eligibility criteria, had secured a less than 45%, which is contrary to the rule, which specifically requires that the candidate want to secure admission should secure at least 45%, and submitted a decision on which the learned counsel for the petitioner had placed reliance pertains to service jurisprudence, whereas there is a decision of Rajasthan High Court directly on the issue of admission. In the case of Dr. Rajiv Mangal versus so-and-so and another, AIR Rajasthan and 2007 Rajasthan 186, it has taken the view that in case the petitioner does not secure minimum percentage of marks, he cannot be held eligible. In the said case, it was specifically held that learned division bench of Rajasthan High Court has placed reliance on decisions of Supreme Court so-and-so, and case of Mridul Dar, and came to the conclusion that the expression minimum percentage of marks should be 50% has to be read to mean at least 50% of total marks, and by applying the process of rounding off, the eligibility cannot be provided which a candidate failed to achieve in the competitive examination. The rule of rounding off, though founded on logic and common sense, would not be attracted in the context of Regulation 7 framed by the medical bill. It is further submitted, Mr. Samri, in the case of so-and-so, and specifically dealt with Mridul Dar case, have specifically dealt with by the division bench that the rule of rounding off is founded on logic and common sense. and would not be attracted in such cases. Therefore, the decision in Pawan's case on which the petitioner reliance placed stands distinguished. Therefore, Lord, in all these cases, the court ultimately applied the rule of rounding off. Para 11 may be seen, finally, where the court applies that principle. Insofar as the case of Mridul Dar and another versus Union of India is concerned, it does not deal with the issue of rounding off marks through state of, though state of MP versus so and so disapproves such an approach on the premise that applying the process of rounding off would not be attracted in the context of regulation for medical council, which operates while preparing merit list on the basis of marks obtained in the competitive examination for seeking admission to PG and so and so. In our opinion, this can be clearly distinguished on facts for the reason that after a person is allowed to compete in the examination, thereafter the assessment of the candidate has to be strictly on merits. In medical faculty or any academic pursuit, even a fraction of mark can make a world of difference and secure place in the merit list. And therefore, the process of rounding off may cause or amount to tinkering the merit list of any candidate with score in between the fraction 0.5 plus, and their marks are rounded off and treated on par with the candidates having scored the whole of the increased value. But in order to enable a candidate to appear for competitive examination, if this well-known formula is adopted, it does not affect any other candidate. Further, it will be inequitable and unjust to deprive a candidate to compete in entrance examination merely on the ground that he or she is not eligible, having scored a fraction of mark less than 45. Apart from the fact that petitioner was provisionally admitted to appear in entrance, we cannot be called upon the government advocate so and so. Therefore, my lord, this is a principle that it is principle of rounding off is in logic. It is commonly used, and that's the three-judge bench of the Supreme Court. So therefore, my lord, one is judgment of the division bench, which the Rajiv Gandhi University has suffered. The same parameteria, same circumstances exist.
I have one more.
ಏನು ಹೇಳುತ್ತೆ? Then, my lord, there is a recent Delhi case.
Ultimately, it has to handle something. See, there is one, I will ask.
Yes.
This, I think it goes. See, a candidate has got 198 marks
Yes.
after the first rounding off, as they have stated. Now you say that another 2 marks is to be added so that they come to 200. To which paper you want to add to that 2 marks?
No, what happens is this.
Nothing. In the statement of marks for each paper, what the candidate has scored has to be given.
Correct.
And that is the criteria which goes for all other
Correct.
aspects in their future.
Correct.
Now that 2 marks, 198 is there. If it has to be, if you take the average of that, it will be 49.5.
Yes.
Now 49.5 has to be added.
0.5 has to be.
Now 0.5 has to be added. That is 2 marks has to be added. To which paper you want to add that?
Lordship, I may be permitted to answer because I was the party for that particular judgment and I argued the matter. In fact, Rajiv Gandhi University has come up with the procedure how the grace marks are to be added in all the cases. They are having the
Which case?
Lordship,
Does
in
the
Nagadivya's case.
Does the regulation contemplate?
Lordship, they have submitted it in.
Where?
Lordship, I don't have it right now. In one of the cases, Rajiv Gandhi
Which
University.
subject?
Same. The petitioner had scored 198 marks, and
After getting the benefit of rounding off in the first instance, then in the second instance also they given the grace mark.
Lordship, the facts were she had scored 198 marks, Lordship. We argued that the percentage is 140, 49.5. It needs to be rounded off to the 50%, and court passed the order. And to implement that, they have come up with a explanation.
What?
How the marks would be
Where
given.
is that? In the
But this
regulation
is-
Be having it.
There in the
Lordship,
regulation.
I don't have it right now, but I argued that matter.
No, it is there.
And,
It is there.
no.
In
it
the
is- it is
university
not- no,
resolution,
It is
yeah?
not this one.
It's not
It is
this.
not this one. They have, and I had filed the contempt petition, and the marks card has been issued to that particular student. It is there. University has come up with a
So
procedure.
what do you say on this?
At that point of time, grace marks were given, madam, because of COVID.
No, grace mark from 199 or 198, the grace marks were given?
To 190, it was given, sir.
No. No.
Well, sir, because they said round off the percentage, because we cannot, in the marks that we had to give them.
Not this
We gave them grace.
You gave them?
Grace
Grace
marks, that point of time. Grace
Over and
marks.
above 199, 198.
Percentage.
It is
One-
there,
but not
recorded.
on-
Not on,
My question is,
at that time, there was no percent.
198 after the first rounding off, right? It may be COVID or whatever it may be.
Not
Let us
on the
not
V1.
bother about that. You might have given at one point of time for
There is
particular
that,
that period, for whatever the reason it may be.
No, 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 the
See,
region.
198 is there. After the
This
first
also,
rounding off,
it could be.
49.25,
Compilation
49.25. So ultimately it came to,
Slightly compilation.
you rounded it
Satish
off
Chandra.
and then said that, yes, 50 and they have. But total is 197, right? At 197, the 3 marks has to be added. Now that 3 marks should go to any one of, any of these 4 papers,
They are not
isn't it?
giving
In
it
your
away.
statement of marks which you are going to issue. So there, if you are adding grace marks for something, that has to be added to particular paper where you will add,
Already stated.
for which you added
They
that.
are not.
Let us say in the COVID,
He's
but
saying
where
very
you
good.
added that? And what is the criteria for that?
Have to verify.
And which is this, which is the marks which you are referring to of which year?
Lordship, 2022 after.
Not after 23.
No,
Well, it's
no,
21 it was, not even 22.
2022.
That is why my learned friend is only speaking about the pre-23 situation, when it was percentage, and therefore the percentages were permitted to be rounded off as a matter of grace,
Where 21 does stipulate percentage rounding off.
percentage round.
My lords,
This is something which has come in now.
That's a fact.
Regulation 2000, it never stipulated marks. It only said 50% there.
We made this
Here,
effort because this,
under 23,
because there were 2
clear.
rounds, as my lord has seen, there are 2 rounds of grace marks given already in the process. So we didn't want again a third round, because a third round would entail at the minimum 3 marks, 3 whole marks to do a rounding off. That's why the
That,
200 upon
That
400.
compilation, page 33, Lord, on the question posed by your lordships, in that compilation, page 33, judgments compilation, this has been extracted by the division bench, previous division. Precisely, this point is answered. Kindly see page 32.
ಮಾಡಿದ್ದಾರೆ 24 ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
This is the COVID situation.
No, no,
Mr. Reddy.
no. For a moment, Lord, kindly see the wordings. Honorable Vice Chancellor explained about the Honorable High Court direction regarding, this is in Guru Prasad's case, first case. Registrar sought the opinion of the syndicate whether to implement the High Court order. Honorable members opined that it is better to implement the order to benefit the student. Honorable Vice Chancellor informed the members there are 3 options. Considering COVID situation, will implement, 1. 2, after implementing the quota, will go for an appeal. 3, we will round off the marks at the evaluator level, which Lordship Justice Joshi had asked. Rounding off marks after taking average of 4+1 valuation, and rounding off the marks after taking total average of the marks. Kindly see that plot. One is first rounding off, and rounding off the marks after taking quota. No, irrespective of COVID. Then kindly see the next paragraph and inform the members to opine on this. Members opine to implement the third option, not the first COVID option, that it was for COVID.
Yeah.
So therefore, independently of that, they said we will adopt this principle. And they accepted the judgment of the court, the syndicate. Kindly see, Lord, the expert body, decision of the expert body. That is the unique facts in these facts and circumstances in this case. So while the same ordinance, clause 4, was prevailing, and parameteria to post 2023, the same ordinance comes. This same syndicate resolution would apply with equal parity to the present situation. Because my lord,
See, that was the discussion,
ah,
but we come to page 34,
ah,
where the resolution is mentioned.
ah, it was recommended to implement the High Court order.
True.
As
There
a
was a
one-time,
discussion on that.
yes, yes, my lord. What I'm saying, Lord, is what guided the syndicate ultimately to bring this? Syndicate was
Correct.
influenced by the fact that
Correct.
independent of COVID also, we will give them.
There was a discussion on that.
Yes.
See, if one or two members mention that, suppose in the parliament, there is a discussion, 40% of the members oppose, 60% vote for it, and then ultimately it is passed. Now, what you are saying is, there was a discussion on this aspect, this is the
Yes.
discussion.
They decided
But
to implement.
What is the outcome of
Lord,
that?
what I'm pointing out
The
is,
outcome is,
yes.
in view of the
No,
prevailing
Lord,
COVID-19 situation, it
for-
was recommended to
for a moment.
implement the Honorable High Court direction,
Yes,
writ petition number so and so.
yes. That is why this later division bench clarified, because these same questions arose. Was it because of COVID that you did it? Justice, the Justice, Chief Justice's judgment,
Right.
division bench clarifies.
Division bench judgment.
So irrespective of COVID.
It do not lift that veil of what happened prior to that order was
Yes,
passed, right?
yes, yes.
But you now raised this aspect.
Correct, Lord, because your
That's why
lordships asked, where did you get this second round of rounding? This is where the genesis is this. It was a syndicate itself. It has not been the position of the syndicate
There are
that
two
we will
things.
never do this.
No, but reference is made to this corrigendum.
Corrigendum.
Corrigendum is during COVID period.
Yes,
But still the court says that
yes, that's
COVID has nothing to do.
nothing to do with it. Therefore, court took the threadbare clause 4 and said that confers the
Oh.
power. Therefore, my lord, it is very clear that there is one judgment, latest judgment of the Delhi High Court, 2023, which elaborately goes into this issue in that compilation. The first judgment, page 15, para 30. Kindly see the highlighted portion, blood. Rounding off, therefore, is a rule in the absence of anything to the contrary. If the rules or other provisions specifically provide otherwise, it would be a different matter. In the absence of such a provision,
But that's not the position. Huh? There are regulation which governs.
here the regulation does not say no rounding off. Lord.
Huh?
Regulation
Ah.
does not say no rounding off. Now, Lord, if suppose their argument is in the first round it is permitted, in second round it is not. Regulation does not prohibit.
That's the intent in that judgment also, the
Yes.
division bench.
Yes, division.
It doesn't say otherwise.
Yes, it doesn't say otherwise. Therefore, Lord, I think today, in view of this ordinance and the same ordinance being reiterated, Lord, post 2023, my humble submission would be that the same paramateria law applies, irrespective of other considerations. Therefore, the division bench judgment governs the situation, and the present division bench, Lord, would follow that division bench and interpret the already interpreted provision, similar provision. It has to be interpreted in a similar manner, and that benefit has to be extended to the students. And finally, that Mriduldar's judgment, 3-judge bench of the Supreme Court said, rounding off is a rule of logic. Logically, it would follow rounding off. The 3-judge bench of the Supreme Court.
Yes, ma'am.
Yes.
Thank you.
Please.
Yes.
And then, Lord, one small digression. When the new PG 2023 rules came, Lord, the university was doubtful whether it could implement that questionnaire pattern. There, the questionnaire pattern was a hybrid pattern of multiple choice questions and thesis questions, thesis manner of question. So what their university did was, it said, even though the new PGMR 23 has come, we will go by the old pattern of 2019 of thesis questions, and we will not adopt this multiple choice pattern.
Okay.
So therefore, Lord, even that questionnaire pattern which is relevant for marking was the old system.
But evaluation was on this.
Evaluation was on this. But again, ultimately, the clause 4 there became the clause 8 here.
That's your argument. Yes.
Lordship, I had filed a memo along with the
200.
illustration of the
But
current.
one just small, page 98 may be seen. Just one 30-second intervention. I'm sorry. University was submitting that now 200 has become the norm. University was submitting. So that's the change. Kindly see, Lord, serial number 3, page 98, Lord.
Mhm.
The candidate shall secure in that 3, column 3, third line. The candidate shall secure not less than 50% in each head of passing, which shall include theory aggregate 50%. Yes, which again, Lord, goes back to the old. The old said, 2019 said 50% aggregate. Cumulative, correct. Cumulative, that regulation 8, regulation 14.
That's even their case also, Mr.
50% is.
50% total. In one or two papers, you may have less than 50.
Yes.
But if you have more in one paper, in the other paper,
Yes.
or fourth paper,
They are all cumulatively
they are
added.
cumulatively
And that fraction is rounded off. Yes, the old regulation, Lord, is.
That's the reason your case.
That's why we are here.
Percentage wise, make it 50%.
50%. That.
Yes, ma'am.
Lordship, I have filed a illustration of
But
calculation.
can I be excused?
Yeah, yeah.
Please.
Hmm? 448. I filed it on 22/5. Rachif, I have taken up an example of two students. One student who has passed but scored a raw mark of 198, and a student before your lordship who has scored the raw mark of 198.5. He has declared as fail and he is before your lordship. Atsita, memo.
You will give where Mr. Reddy had appeared in which appeals, and in other appeals, who are the appellants. See, we want very clear appearance in all the appeals.
We are respondents, my lords, in all the appeals filed by.
We are taking your submission.
Yes.
We are going by what you have said. All the appeals are between both of you. That we take it?
Yes, my lords.
You will give your appearance in each of the appeals.
Yes, my lords.
We don't, and we take it. There is no other counsel in, no third counsel.
No, my lords.
Yes, ma'am.
Lordship, in that memo, I had given marks of raw marks of student
Ma'am, where
A.
is that memo, ma'am?
I filed it on 22 seconds.
But I have my copy.
This is, let's see from the record.
This one.
Yes,
What does it say?
second page. Second page.
Go ahead.
Lordship, the marks of student A, he has scored a 45 plus 46. It comes to 45.5. They have rounded it off to 46. If their,
In the chart also.
yes, if their argument is to be accepted, it will become 46.
That's right.
Similarly, for paper 2, 50 plus 51, 50.5, it will become 51. Third
We are
paper,
comparing with the next candidate.
yes, same
See
thing.
that paper 1, student B,
Hmm.
45 and 51,
Please, Lordship.
it has become 48.
48.
That's right. So what you are saying is, applying the
more-
same formula,
More
in
number,
cases, though the first candidate, how much he secured? 198?
198, but then it was rounded off to 200 because he had more number of decimals. And in the second case, he had only two decimal in papers, 2 decimals. So it was, he was declared as failed.
So are you saying after following the first limb of the benefit of rounding off, then a further benefit was given?
Lordship, for him, as of in this, further benefit was not
given.
Not given.
So how are you drawing these
Yes,
examples?
Lordship, I'll come to that. I'll come to that. If this is permitted, the bias would be created because a student scored less than student B is pass.
But that's the effect of the rounding off in the
Yes,
first.
Lordship.
That's right.
That is the reason I'm making a statement that the bias would be created if only first round rounding off is permitted, because immediately after the evaluation, this is the result. Because the rounding off process is a dynamic one. Lordship, if the same rounding off permitted in the second instant, like after computing the marks, then this bias will not be
Where
there.
will we draw a line? How
Lordship,
many benefits?
Lordship, I'm not asking for.
No, it's important.
Yes,
We
Lordship.
will tell you why. We'll tell you why. A person who gets 198 will come saying that you have given the benefit of rounding off to a person who got 199. I am 198. You should give me.
Lordship, what I am saying is, instead of giving it to the first instance, you give one rounding off in the second instance. Then there will not be a bias, and
Where will we draw a line? That's what we are saying.
only once
Which
I'm
case?
asking.
Sorry to interrupt. In which case the arithmetical calculation would have meant it would be 196. Please see that. He would have failed 49. She's arguing against herself.
No.
Ma'am, if you see,
It will be 196.
the first one will, how much score will 196
No, he has scored 198.
after rounding off?
After rounding off to 200.
So 0.5 into 4 will be 2 marks. Minus 198, it will be 196.
No, that they have declared it as a pass. They have declared it as a pass, 198.
So 198 should be made as 200 according to you in the
Yes.
second round.
Lordship, yes, the rounding off should be given effect to in the second round.
Suppose if you are not given in the first example in the first round, what is the effect?
Lordship, if rounding off is not given in the raw marks, it will become 198, and then this 198 would be rounded off.
How will you, what principle you will evolve?
Lordship,
1 minute, just listen to us. What principle you will evolve when you have 198 to rounding off to 200? That means 2 marks need to be given. 2 marks, that's right. Where will we draw a line? Why 2? The 197 will say, make it 3 marks. 196 will say, make it 4 marks. Where are we drawing a line?
Lordship, I'll come to that, Lordship. Lordship, as per the university, PGMR, 8.4 says that there shall be 2 evaluators. And the total marks which will be given, it would be 800. There'll be 4 papers, 2 evaluators, and then 800 marks. But marks permitted is 400. To get into 800 to 400, a mathematical equation is needed. So the minute you include mathematical equation, it will become a percentage. Then if the percentage is permitted in the PGMR, I am permitted because 198 would become 49.5, and I am allowed to round it off to 50. Even,
What
the
it becomes?
second
198, how much it becomes?
50, 198.5, it will be 149.5 will become 50.
But that's on the basis of first rounding off.
No, Lordship. I am asking for the second after this 198, I'll divide by 4 and then I am asking for a rounding off. I'm not asking to round off the raw marks. I'm not asking for the raw marks because according to me, the bias will be introduced there. Because more number of decimals, the more number of marks.
Let's assume this very well. In paper 1, which marks need to be taken? 45 or 46?
46.
Why?
Lordship, the 45, even for computing the results.
Let's see that.
Please, Lordship. 45.5.
Now let's count your first marks. 45, 50, 46 and 51. How much it comes to?
Lordship, one submission, Lordship. This marks 45 plus 46. These two are the marks awarded to the petitioner by 2 evaluators.
Right. So between the 2 evaluators, how would you come to a conclusion which marks to be taken? Average of it. So best way is to average
it.
So average they have done to 45.5.
Yes.
Okay. Now the question has come. There is a decimal point.
Yes.
Now the question would be either we retain the decimal point and work out the merit.
Yes.
That's one.
Yes.
But they thought, let's give the benefit to the candidate. Let's not, because there is a possibility, because the rule says you should get 50%. And in individual papers, you can have less than 50. So they said, let's give the benefit to the candidate and let's round off. Round off means it will go up, it will not come down. So that's the benefit they sought to give you. 45.5 has become 46. It inured to the benefit of the candidate. That's right.
Yeah.
What is wrong?
Lordship, I'll make my submission. Here, if there are more number of decimals, the marks awarded to the particular student will become more. If you do the rounding off at the first level. And if the entire mark is calculated and then rounded off, the bias will not come into place.
What is the bias?
Bias is 49.5. The giving the marks for how many number of decimals are there, that many time the matter is the marks will get rounded off, and more marks will be added to that.
In essence, this would indicate more marks without decimals. I mean, without rounding off.
Now,
yet he is declared fail and the person is declared pass.
Lordship, the student B has scored more marks, but he has declared as fail.
Student who secured less marks is declared as pass by giving that benefit. In essence, he secured more marks.
She gets 50%. It's more than 200. So why are you making it ever? But this can't be. So this means a second evaluation. She could have better option. You can only argue, but that may not be sustainable in law, because between the 2 evaluators, whosoever given the more, you should take it.
Lordship, in fact, if they give the key answers, this entire question wouldn't have come. Here, our condition is such that, except to the 2019 regulation, all the regulations issued by the RGHS has been set aside by this honorable court on the submission made by the NMC that it is not in consonance with the NMC regulations. And every time when we go before the university and asking for the discrepancies in the valuation, they just don't listen to us.
What is the other point you are?
Lordship, this is the first one, Lordship. Lordship, now PGMR regulation itself, they say that there is a 2 evaluators, and then they give the permission for the deviation valuation if the difference between 2 evaluators is more than 15%. This 15%, they have given a benefit to the human error. And thereby they are admitting that there will be a difference in the valuation. And because of their mistake for not conducting the evaluation properly and in a transparent manner, the students are suffering.
No,
Between
how
two,
would you say so?
Lordship, that is what they have.
I'll tell you why that position is.
Huh.
50 difference between two evaluators is more than 15, there would be an arbitrariness. That's right. It's to obviate the arbitrariness, they said we will refer to the third evaluator.
Yes, Lordship.
That's the intent.
Yes, Lordship.
15% is a huge difference
Yes,
between
Lordship.
two evaluators.
Yes, Lordship. I bow down to that. But they admit that there is a human error.
There can be.
There can be,
Obviously,
yes, I
ultimately
bow down to that. I'm not disputing it. They have admitted that there is a human error. They have permitted the human error as far as the evaluators are concerned. They have not taken any step to correct the process of evaluations, like
Can be the process of
Lordship, in fact, there are so many cases before this honorable court asking for a key answers, and always,
See, this is theoretical, na?
no, even in that,
This is theoretical.
theoretical and key answers needs to be provided, and that is the stand of our NMC.
No, there cannot be a answer key to a theoretical answer.
Lordship,
Objective type, yes.
Lordship, key answers does not mean that entire the answer should be exactly verbatically same. But then in the medical answer, valuation of answers, there are the marks are awarded to a student based on how he analyzes the
That's right.
patient or the situation. Here, what happens is each stage. For example, patient examination, how the reference has been done by the student. In the answer, he would have written that. And those things, they could have given as a pointers like, and if those pointers are covered as per the text which have been prescribed by them, they should have given the basic marks. At least 1 or 2 or a minimum number of marks and maximum number of marks if a student is covering that particular aspect of the subject. Here, nothing, Lordship. They have given full free hand to the evaluators, but then for us, 0.5%, 0.25%, they are making us fail, and our entire year is gone, Lordship. And next, this one, Lordship, time and again, students, NMC is telling RGHs, you provide the key answers. They are not giving it. We are asking, even it is there on record that they will implement certain
How is this relevant for the issue?
Lordship, because they have not done our evaluation properly, we have suffered the order.
And that's a different
on
challenge.
that is the reason.
You are challenging the method of examination itself.
No, Lordship, I am telling in Guru Prasad's case, because university has not done its work properly as an equitable
Why did you
remedy.
appear in the exam? You should not have. See, this valuation is wrong. Do it in this manner. Why did you return exam? Obviously.
Lordship, kindly turn to Guru Prasad's
Not
case.
argue both.
Suppose you got 50% mark in total. You would have challenged the process. You say, oh, I am so happy I got more than 50.
Lordship,
Been satisfied?
Lordship, in fact, many students have passed in the
If
supplementary exam, and they want to.
We must say that Mr. Chinnappa has given the statistics.
Yes, 6 students have
Absolutely.
passed it.
It's a huge percentage of pass. Out of 2,849 candidates, 2,583 have passed.
Yes, Lordship.
Only 265 have failed. See,
Lordship-
minuscule.
Lordship, in fact, only 77 students on the last time, Lordship, 77 students have failed with 1 to 3 marks.
See, this would take us to, suppose now 197 is there, you want an add a grace. right? Now suppose, let us say they declare that 197 is the required marks. Then there will be an argument, 195 should also be made 197.
Lordship, kindly
Isn't it?
turn to Guru Prasad's case, Lordship.
195, he has only 2 marks to so add it. So where is the end?
Lordship, this court,
Where will we go thereafter?
Lordship,
In case of any ailment.
Honorable High Court of Karnataka has permitted 3 decimals, that is 199.25.
That's what. Let us say, they accept your argument. They make it 197, where 187 will now be eligible. So after that, you will make one more argument saying that 195 should also be made eligible.
Lordship, there I will not be having this logic, Lordship.
Same
No, Lordship, I will not be having this logic because there is no decimals. Because the decimals permits only 0.25, 0.5 and 0.75. Lordship,
Because 40 and 50, 40 is the minimum for each paper to be qualified, and 50 is the overall.
Why do you say 0.25, 0.50, 0.75? He will say make it 1.25. He will say 1.50. He can say, obviously.
Lordship,
That's what we're saying.
all
Where to
those
draw a line?
formulas have tried
That's
and
why.
lost, Lordship.
If it is 197, let us say 200, they have said 200 out of 400. They will say 197 out of 400. Now there will be an argument that 195 should be treated as 197.
That's all. Any other matter, ma'am? You have to
Lordship,
argue, na?
Yes, Lordship.
That's all, ma'am?
Lordship, in Guru Prasad's case, Lordship, in para 3, the court has said as follows, Lordship, the reasons for permitting the rounding off. Page 104, Lordship. Para 3, A. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant relief to the petitioner as under for the following reasons. The digital valuation slips of the petitioner at Annexure C series show that 5 evaluators were not provided with key answers. Therefore, in terms of the judgment in case of Ms. Nischita versus RGHS in WP number so and so, decided on 6/6/2018, there is an infirmity in the valuation process. The contention that the said judgment shall not be treated as a precedent, even if it is accepted, would not come to the rescue of the respondent university, since the parity factors, if not the precedent. However, at this length of time, it is not worthwhile to subject the theory papers for evaluation afresh, and some equitable relief needs to be granted instead. And as per the exam norms of the respondent university, for passing the examination, a student has to secure 50% in theory papers in aggregate and 50% in the practical plus viva voice. The petitioner has secured 49.75% in the theory papers and 70% in practical plus viva voice. Paragraph 5(1)(b) of the subject ordinance read as the average of the best 4 total marks for the paper awarded by the 5 evaluator, which is rounded off to the nearest value, shall be considered for final computation of the results. Since arithmetically petitioner has secured 49.75, the said figure has to be rounded off to the next whole, that is 50%, Lordship. And because the university has not complied with the direction of the honorable court and they have not given the key answers, and there is inconsistency in the valuation, we got this relief, Lordship. Even as on today, the situation remains the same. There is an inconsistency in the evaluation, and the evaluators are not given with the key answers and
But why didn't you challenge the process? You should have challenged. Huh? Look here, this is not the way.
Lordship, the process has been challenged in other writ petitions, Lordship, and they are pending.
But you have done it. But surely it has no bearing here. You have not challenged here. We are concerned with this.
Please.
That's right. Yes, let's hear it. Yes.
Please, Manoj. I'll not repeat, Manoj, the arguments that have already been made. Manoj, from that, I'll just take a gist out of that, Manoj. When it came to the interpretation of postgraduate medical education regulations 2000, that is the older regulations, and Manoj's corresponding universities regulations, court has interpreted, university has accepted, implemented, students have already been given the benefit. One other point that needs to be noted is Manoj, NMC had never challenged those Manoj's judgments. At that time, there was no challenge by NMC. Manoj, the different line of argument that I have, Manoj, here, all students before your lordships are, Manoj, admitted for the academic year 2021 and prior. Nobody is, Manoj, after post 2023. Manoj, at the time of our admissions, the regulations that were governing to us were postgraduate medical education regulations 2000. The entire curriculum, entire work that we have done, Manoj, is under the old regulations. PG, MER.
What is the submission?
Manoj, that the regulation.
The old one which will govern you?
Yes, Manoj.
How do you say so?
Yes, Manoj. I'll come to that, Manoj. In education jurisprudence, Manoj, students are classified under which they are admitted.
So 2023.
And they continue. We are called as, Manoj, by the university as RS3 students, revised scheme 3 students, under which curriculum is fixed by the university based on regulations of the NMC, and we study that curriculum.
So 23 will govern which
students who are admitted under 23. They will
which in the postgrad in the MBBS
in post graduation, Manoj.
Post graduation.
Yes, Manoj. Okay. They study, Manoj, under the new curriculum. They are categorized as a different student.
Why did you appear?
Manoj, it's separate examination. Examination and the criteria are same. There is no change in the.
But your evaluation is under 23.
Manoj, evaluation is a different aspect, Manoj. As per the requirement for passing is the same. We fall under the old one. Manoj, even Manoj, the percentage of marks between the first and the second examiner is.
Did you take this point below?
No, Manoj. Why it is not relevant, I will mention, Manoj, because that is not in dispute, or rather we have not contended that that is wrong or otherwise. Malot's difference of marks between the first and second is 15, which is rounded off, and then Malot's given. That's a different aspect altogether, which does not concern us, or we are not challenged that aspect of it at all before the learned single judge. So in fact, my lords, university had, my lord, specifically just before the examinations, instructed the students that the examinations will be conducted under the old regulations.
But the issue which has been decided by the learner single judge is only the rounding off.
Rounding off has got no relevance, my lords, to the regulations, is what my yes. That's my lords, because the court did not emphasize which regulation it is my lords, interpreting of the NMC's regulations. It did not go into any of it. That entire aspect has not been looked into by the court, neither answered also.
How do you say so?
Yes, my lords. Because no interpretation was given to any of the regulations.
But what was to which regulation the reference was made?
Well, its reference was made as regarding the rounding of orders that were already passed in terms of universities regulations. Yes.
See page para 9, page 67.
Yes, Manoj.
PGMR 2023.
Yes,
Regulation 8.4.
But those are not interpreted, Manoj. It is only referred. But there is no interpretation of any reference, because, Manoj, the court only wanted to say that there is no prohibition. That's why that was extracted.
There is your petition.
Manoj, in my writ petition, I have contended that I fall under the old regulations. My writ petition, unfortunately, Manoj.
Did you challenge this order?
Which?
Did you challenge this order? Of
no, Manoj. It is rounding off which is given to me. Benefit that
based on 8.4 interpretation. Based on 8.c paragraph page 68.
Yes, Manoj.
Does not explicitly prohibit rounding off.
Yes, Manoj.
That's the finding. That's the basis conclusion. So every reference is to 8.4. Interpretation is to 8.4. It doesn't prohibit rounding off. And that's the conclusion. And that's para 10 is the direction.
My lords, why, my lords, this is a judgment, my lords, that had already been rendered. I am not a party in these petitions where this first order came, my lords. This first order.
No, we are concerned. Were you a petitioner in this batch of petitions?
No, my lords. In my batch of petitions, court has followed this order.
What is your batch of petition?
My lords, writ appeal 638.
Well, it has followed this judgment?
Yes, my lords.
Based on 8.4 interpretation?
Yes, my lords. But I had contended, my lords, in my petition that the regulations.
Go back, file a review. 8.4 has no applicability. Go back.
No, my lords. Applicability would arise, my lords, if some interpretation of that regulation is applied to me. The court has only looked into a regulation saying there is no prohibition.
Okay, so let's.
There has been that level of confusion, or my lords.
But tacitly, you are accepting the interpretation given to 8.4, based on which the benefit has been bestowed on you.
My lords,
are we right? Yes or no?
My lords, I would interpret your lordship's statement in a different manner. My lords, if 8.4 had some specification, it was interpreted and given a benefit under that 8.4. Well, that would amount to interpretation of 8.4. Court has not looked into 8.4.
And the benefit thereof has been given to you.
No, there was no interpretation is what is my respectful submission.
8.4 interpretation, a judgment comes. Then you go to the learner single judge. The benefit of the judgment has been given to you. What does it mean?
Well, may I take it one step behind and show your lordships what the regulations are?
No, we want to answer this. We want an answer from you on this. What does that mean? That means you got the benefit of 8.4 interpretation as given by the learner single judge in the first round of litigation or in the batch of first petitions.
My lords, I had contended otherwise, my lords, in my petition.
They have. Go back.
But it's a question of law which I can place it before your lordships that the regulations have to be applicable in the first place.
Then we will ask you this.
Yes, my lords.
Are you disagreeing with the interpretation to 8.4?
My lords, interpretation of 8.4 has no relevance to my case. Even if it is interpreted in any fashion, my lords, has no relevance to the case.
File a review. Obviously, you have to go back and file a review saying that my case is this, old regulations are applicable. Those old regulations have been interpreted. I should get the benefit.
May I make this statement before your lordships? Now, my lords, the university as well as NMC are before your lordships saying these are the new regulations which are applicable to us. It has to flow from the regulations. My lords, it has to flow from the regulations that it is applicable to us.
But we will only put it, there is no finding on that by the learner single judge.
Exactly. My lords, that's exactly what I am trying to say, my lords, that there is no finding on that fact.
Go back.
Very well, my lords.
Review.
Yes, my lords, your lordships direct us. Direct all the, my lords.
Let's be very clear. We will not. The submission is coming from you. We are putting it to you. If this submission, where is the finding? There is none whatsoever. What is the remedy? Review is the remedy.
My statement or my lord's counter statement to your lordship's question would be.
You have not availed that, and therefore you cannot argue that.
No, my lords, sir. I'm bringing to you, because this is an appeal, it's a question of law, my lords. I'm placing this before your lordships. It has to flow from the regulations as to what are applicable to us. University NMC has issued several communications directing.
The finding. Where is the finding?
In which case, my lords, I would pray that your lordships direct it to be reconsidered.
We are not saying anything.
None of us.
You are a respondent. You have not filed an appeal. We are considering the learner single judge judgment.
That my grievance is not considered.
It is a contention that I have raised.
Petition here.
Yes.
It's not a contention
It is.
taken.
It is a
It's not
contention.
a contention taken.
That's a writ petition.
Yes, I have the
Let me read it from my
He
writ
relies
petition.
on it entirely the order of the learner single judges. Give me the same benefit. That's the entire.
Oh, he says so.
He produces the order itself.
Let
Where
me
is the
read
writ
from my
petition?
petition.
Where is your writ petition?
I'll just read it.
And let's see the prayer.
Yes, my lords.
Where is the writ petition? Which writ petition? Which appeal?
Writ appeal, my lords. Learned, my lords, university has not placed my writ petition in the writ appeal, my lords.
Mr. Chinnappa, just give us that.
Also, we'll see that the only document that is produced is the regulations and the order of the learner single judge.
Yes, regulations of 2000, my lords.
2019.
Yes, my lords. 2019 ordinance is under the old regulations.
See your prayer.
My lords.
You have seen?
Yes, my lords.
See the prayer.
My lords, my contention is, my lords, in the petition that I fall under the old regulations. I've stated so.
Forget it. You see your prayer.
prayer should have been that these regulations don't apply to me at all. And therefore, the question of interpreting it doesn't, that's not his case. His case is follow this, and the order of the learned single judges, which is his contention. This is the order of the learned single judge. Please follow it and give me the benefit.
Lords,
A new argument is being made.
2019 ordinance is applicable to us, to me, which is under the old regulations. That is applicable. I have not stated that the new regulations of the
See your prayer.
let's to follow and give me the judgment.
That's all. What does the learned single judge say in the judgment?
Rounding off, my lords.
On what basis?
My lords,
On an interpretation of?
my lords, I would,
On an interpretation of?
my lords, if it was an interpretation of a regulation, specifically 8.4, my lords saying, okay, this states this, and I am interpreting it in such a fashion, my lords, yes, I would understand that to be an interpretation. But court has only referred to 8.4 saying there is no prohibition. There is no prohibition, my lords, is not an interpretation of the regulations, my lords, my respectful submission.
8.4 submission is there is no prohibition. That plea has been accepted by the learned single judge and benefit thereof given.
After interpreting 8.4, it has opined that there is no prohibition. Without interpreting, that cannot be said.
You should have
Can
said.
it be?
Oh,
What is
yeah,
your
man, we are not
logical,
saying anything.
conclusion?
You will proceed on a premise. 8.4 has been interpreted in this manner, which you have not disputed. Now make your submissions. That's all. That should be the scope. Forget all
Ballots,
the
this would, ballots, but the argument that I have raised would become an argument in law,
We say nothing.
which,
You go there either in appeal or.
because, my lords, if your lordships are looking into the regulations, that yes, 8.4, even though it is not, there's no prohibition, and your lordships are looking into that question, perhaps, my lords, your lordships could widen the scope and include this question.
We are in an
I would
appellate-
contend, my lords.
We will in an appellate jurisdiction. You have not filed an appeal. They have come in an appeal of a judgment which interprets 8.4. We are only looking at that.
This
the
question
reason
would
we
be
say-
relevant to that also is
One
good.
minute.
Yes, please.
That's the reason we say, if your case is different from the other appellants, you will go back to the learned single judge and mind it. I don't know for how long, for whether you can actually argue that when your prayer is to give the benefit of that judgment. You can't even argue that. But besides that, go back saying that this is my case, please give me an interpretation on my previous regulations and give the benefit of rounding off. That should be your case. Whatever the judgment, if you are still agreed, come back. That's it. But not in these appeals. That's how.
Would your lordships be open to just see the regulations, my lords, as to when, what regulations were
We
brought
will
into
not
place?
see.
Your lordships had, you asked one question to which I wanted to answer, which was raised to the learned council, my lords. Has this benefit of rounding off being given to students post 23 is a question that your lordships asked. After the new regulations came in, has university done it? My lords, from 23, this was in November 2023 regulations. This was interpreted for the first time in January 2025 examinations. That is the one that we took up. Entire 2024, whatever examinations university has conducted under the old ones, even though the new regulations were enforced. This is a factual aspect which your lordships could, my lords, verify from them. Answering to your lordships earlier question raised, my lords, to the bar. Perhaps that, my lords, would also indicate that they also understood it to be something that is applicable.
Two things or one thing there. Holding examination on a particular pattern is different from evaluating the answer sheet. The evaluation is under 23. Let's be clear. Getting the point? Pattern is one, evaluation is other aspect.
Examination.
We are concerned with
My
evaluation.
lords, examination would be a single aspect. Would include, my lords, question paper, evaluation, everything. Announcement of results would be a component of the whole, my lords, aspect. So, my lords, how?
What, did they issue any notification for the examination?
Yes, my lords.
Where is that?
Yes, my lords, I do not have it right away. If your lordships could take it up at 2:30, my lords, I'll place it on.
We can't take it.
2:30.
Because we have spent a lot of time here and we have a huge board today. And we have other fixed matters also.
Because, my lords, that was not placed before the learned single judge, because that question was not argued. Your lordships have asked this question. I will place that document where university has said the examination is in the form of 2000 regulations, PGMER 2000 regulations, just 1 week prior to examinations. I'll place it before you.
They have stated.
So, my lords, in that view, we students do not know what is being implemented by university. University conducts evaluation, announces the results, and after that is when we come to know. 1 week prior to examination, notification is issued. Examination pattern, everything will be in terms of PGMER 2000, because there was a confusion. For one whole year, they did not follow. After 1 year, Yes, my lords. Please. Copies idea? Scan it. Provide copies, lordship and LEC. Just 1 week prior to examinations. In December 2024. Copy. December 16 December. Ida. ಇದಲ್ಲ ಮೇಡಮ್ ಇದಲ್ಲ ಇದಾದ್ಮೇಲೆ ಯಾವ್ದು 26 ಡಿಸೆಂಬರ್ 26 ಡಿಸೆಂಬರ್ 26 ಡಿಸೆಂಬರ್ 20 ಡಿಸೆಂಬರ್ ಅದಾದ್ಮೇಲೆ
See, but you see the notification.
My apologies.
Notification says we'll just read it. So what says here, with reference to the above subject, 2003 is released on this day by the National Medical Exam Commission, wherein 8.3a, it states that the theory examination for summative examination shall be in 4 theory papers. The first and fourth page shall be the basic medical science, recent advances respectively. There has been numerous queries regarding the distribution of syllabus papers wise in each of the MD/MS course. Though the strict division of the syllabus as a matter of fact in the post-graduation course of medicine is not commensurate. According to the expert faculties, the university is hereby providing following clarification. The paper-wise division of MD/MS syllabus will be as per the previous year only. As per MCR 2000, one paper shall be the basic science and this. And what they say is regulation clearly and included in the basic sciences recent advances in question paper, which is similar to the GM. So what they say is, for the purpose of syllabus, they are following the old one.
Question paper pattern also, the inclusion.
Doesn't make any difference. But when it comes to evaluation, and they make reference to the PGMER 2023.
Well, let's kindly see this very statement, Malod, just 1 week prior to examination, creates a lot of confusion as to what they're interpreting, what is being implemented.
So we take it, this is only with regard to syllabus. That's right.
Question paper pattern also. Syllabus means question paper pattern.
Obviously.
Yeah, the entire
question paper is a reflection of what syllabus is. That's right. But not evaluation.
Malod, right? Malod, evaluation is a composite part of the examination. Malod. Evaluation would be a part of the entire process. It would not be a separate.
That evaluation will be as per the old regulations.
Malod, they do not say. Malod,
is a confusion then.
Malod, the confusion is what they are in.
Okay, that's all. Now comes
to
the merits.
What requires, Malods, under the new regulations is a completely different set of requirements.
To the merits. What do you say?
Malods, this would be, Malods, to look into in that.
Very well, we look into it. And mind it, that was not your case. That was not your case. It was not. Are we right?
Malods, because.
Are we right?
Malods, I would say.
Are we right?
Malods, that was, Malods, not answering. Not argued that, Malods, yes.
Lordship is right. I learned to say it thrice now.
A query comes from the court, answer it, and then proceed. Yes, but I have this submission.
Yeah, Manos, I did accept earlier, Manos, by saying, yes, this is a question of law that I'm raising, which your lordship.
We did not hear yes or no.
They must have grace.
I nodded, Manos. I did accept it last time. Yes.
So let's go by strict law of pleading, the prayers, everything. To be very frank, going by the prayer, you had no issue, except the benefit of 8.4 must be given to you. You actually had no issue. Though you may have made a part of the pleadings.
Yes,
you know, I was regulated, you know, based on this.
Because benefit was already given by learned single judge based on Malod's judgments, which were interpretation of the older regulations. Malod, there was no point of contention at that time.
You are actually right. If I had been your place, my prayer would have been the same. I am concerned with the relief to my client. That's your intent. You prayed so, because there is already a judgment. Prayed so, that's all. So that's the point. Now come 8.4. What is your interpretation?
It's same arguments, Malot says. I don't want to repeat it, except Malot, all these things are in para materia with the other things. It just perhaps Malot, if your lordships could see PGMER 2000 as regards the.
Your argument is, in effect, is what Mr. Reddy has
Absolutely.
argued.
Just one thing.
Interpretation given earlier.
Yes.
And para materia regulations, the previous one and this one.
Yes.
So there cannot be any different interpretation.
One other thing that I just wanted to point out, Malot, in my repetition, if your lordships could see, perhaps Malot has contempt 383 Malot. Contempt petition 383 of 2025. Because this document is not placed in the appeal, Malot, I'm referring to the contempt. Malot, page 29 of the contempt, Malot. Malot has the exam results. Exam results, Malot. The requirement for passing is provided in the results itself. Minimum to pass. Minimum to pass is 50% in practicals, 40% in paper, so and so, which is not in dispute. All of us have cleared that 40%. 50% in theory aggregate. So the requirement is still the same as was earlier, that I have to secure 50% for declaration of pass. This 50% is, Malot, is what is being interpreted earlier to say that this has to be rounded off. If my percentage is, as it stands now, 49.25 or 50 or 75, it has to be rounded off to 50%. This will be awarded, Malot, in the last column of that results. Last column of grace marks for the students
So
earlier.
what your argument is, even for percentage, it can be rounded off.
That is what was done last time also, Malot. Not 200 marks. The court did not interpret Malot, that these other individual paper marks will have to be rounded off. The interpretation that was given earlier also was on this first percentage of 50%. That is why, Malot, if your lordships were to see for a moment, PGMER 2000, what is the requirement? If your lordships, I just passed it. May I just read it, Malot? I'll just read it. What is the requirement? Yes, Malot. PGMER regulation 14 is the examination. We have given, Malot, separately. I'll just read this. Obtaining a minimum of 40% marks in each theory paper and not less than 50% cumulative in all the 4 papers for degree examination and 3 papers so and so shall be mandatory for passing the examination as a whole. So there also is a statement of 50% aggregate for passing. In the new regulations also, it is 50% aggregate for passing. In the result sheet also, Malot, it is 50% for passing.
New regulation does it?
Yes, yes, Malot, it does. Writ appeal number, Malot, your lordships, 448, page 98.
No, the 95, if you see the first appeal, which Mr.
Writ appeal 448, that's first appeal, Malot.
448.
Yes, Malot, in page 98. Passing minimum for practical, Malot,
passing minimum for theory.
Criteria for evaluation, so and so, for, yes, Malot. Theory aggregate 50%. So for passing, the candidate shall check out not less than 50.
It's a theory aggregate.
Yes, Manoj, in the table serial number 3, in the table serial number 3, Manoj, in that third one, within that third one, which is Manoj 3.1, theory aggregate is 50%.
So this only answers that even a percentage can be rounded off.
Yes.
That's what.
Yes.
But where is the rounded off principle? How you will put in operation the
rounding off principle was by the court. By interpreting this to say, when reading the regulations, that there is no, whereas there is rounding off permitted in other aspects, which is a permitted practice under the regulations, the old regulations as well as the new regulations.
There is no prohibition.
There is no prohibition. That is why by interpreting this requirement of passing, we are saying 49 points so and so will have to be rounded off to 50. Taking over, looking into all other aspects, Manoj, of the evaluation. Because court is aware, learned single judge is aware, my lords, as to the manner in which
Okay.
answer papers are generally evaluated and the erratic valuations which the court sees day in and day out.
Point taken. Just 1 minute.
Yes, my lords.
If you are rounding off from 49.50 to 50,
Yes.
under which paper the mark shall be increased?
Great.
That's one.
Last column only, my lords, where the university had added as grace marks. They would add it there by saying it is being interpreted, and the previous results where they had announced it,
Now,
they added it there and not to the individual paper.
let's assume
Yes, my lords.
when there is a bar to not to give any grace marks, because effect is, though you are increasing the percentage, the effect would be on the marks also.
Where it would have to be added, my lords, is if your lordships come to the results, the total results that they announce, there where they say minimum of 400 and total marks 800, that is where they have to add those other additional marks and compute it as 50%.
Will not be construed as giving a grace mark.
That is again, my lords, interpreted by learned single judge by saying grace marks is different and this is different. This is rounding off. It would not amount to a grace marks. Is a interpretation, learned single judge has stated so, my lords, in the order that this cannot be interpreted as grace marks. This is to, my lords, offset other aspects of evaluation. Where, my lords, kindly, my lords, see, these are not students, like by NMC's statements, my lords, that was made, that they are not unfit to be doctors. They are already worked for 3 years. 1, 2 or 3 marks does not say, my lords, they are unfit.
No, we are not.
Having, my lords, already secured more than, my lords, 50% marks in their practicals.
Go by that.
Absolutely. To that, my lords, effect to offset.
Eligibility. We are only on an eligibility.
And, my lords, as regards the other statement that was made, that wherever the examples were given, my lords, of Honorable Supreme Court judgments or other judgments, all of them were, when it came to, my lords, inter se merit. When there is a ranking system and you have to calculate inter se merit and, my lords, or employment based on marks, there cannot be a round off, because you have to judge each other as against the marks. That is why there is no rounding off. This is not such a situation where, my lords, we are judged against each other. It is only to cross the line. To that effect, my lords, rounding off is permissible.
Now, if you see 8.4b.
Yes.
8.4b contemplates rounding off.
Yes, ma'am.
It only contemplates in one eventuality.
Yes, ma'am.
Well,
absolutely.
There is no second eventuality prescribed.
Absolutely.
So the interpretation, what submission is, wherever they wanted to have a rounding off principle, they have expressed so in the regulation. If they have not expressed so, what does that mean?
The earlier, so the counter argument to this would be, my lords, this is the exact situation that was there earlier also. There was a permission for rounding off of marks under the old regulations, where the court looked into it and stated that there is, in other aspects, there is rounding off. The fact that there is rounding off in other aspects and that there is no prohibition to round off here, court interpreted and said, no, we are going to permit rounding off here.
But tell us one thing.
Having implemented the judgment, then they cannot come back and say, no, I'm going to hold you separately as against them, or when the situation is identical.
Okay. So that's the point, the interpretation, what you're saying, wherever they said, they have said, but they have not expressly said it would not be a rounding off in percentage.
A prohibition would come, my lords, expressly. If it is expressed, there is absolutely no argument. Our case ends right there if there is a prohibition.
And then they
To that
accepted
extent.
the judgment.
They've accepted all the other judgments. Results, hundreds of students have come out.
Okay.
NMC is party in all the cases.
NMC is party in all those
NMC is
cases.
party in all cases.
Okay, we'll ask them. We'll ask them.
Yes, ma'am.
That's all. Anything else? That's all?
Yes.
Come, who would answer that? The NMC need to answer that.
We'll answer.
The interpretation sought to be given is, though you have prescribed rounding off at the initial stage, there is no, it's silent insofar as the rounding off at the second stage.
Yes.
An interpretation has been given by the courts that there is no prohibition for a further rounding off, and the benefit thereof having been given, having been accepted, having been implemented, the same principle would govern this also. What do you have to say?
First
You
of
must
all,
keep it in mind, those judgments have been interpreted, that's implemented.
yes, those judgments have been in the context of the earlier regulation. In the first instance.
So are you saying those
where,
are paramateria not same?
No, they are not in paramateria. And in those cases, there used to be 4 valuators per paper. This is only 2 valuators.
What difference it would make?
It makes a difference because then it makes it even more difficult, because when there are 4 averages to be done, it pulls down the marks. In fact, this is a much more liberalized scheme.
No. That may not be so relevant. It may not have a bearing. 2 valuators or 4 valuators. But the in principle is that you would take average of 2 valuators or average of 4 valuators in that case, and then give marks, and then rounding off. We are basically concerned with that, rounding off. You have done the rounding off there. Now comes the second stage.
Yes.
When it comes to percentage, there also, based on the first rounding off, people have got 49.25, 2550.
Yes.
But
I'll complete
the
that.
court has interpreted to mean the second rounding off to say there is no bar, express bar. That has been said to mean when there is no express bar, you can round off at this stage also. That's the interpretation.
In the old regulation, there was no bar at all for any stage, which was utilized by the university.
No, there was. Ordinance was interpreted.
No,
Ordinance
our
itself was
regulation.
interpreted.
Our regulation. NMC regulation.
We will show you that. See rule 4 now. What was sought to be read? Clause 4.
No, my lord is taking.
No, the clause 4 of the ordinance, which was read, which was governing the earlier scheme. You see page 100 of the page 99, 100.
Universities regulation.
That's university's order.
University's order.
Oh, this is university's
Universities,
order.
not ours.
The regulations don't have.
Our regulations did not have any bar as far as rounding off is concerned. No reference to rounding off was there in the fashion in which it is here with regard to rounding off. Therefore, we didn't have anything.
But how do you?
We did not deal with it. We did not deal with it because there was no express. So that is now I will distinguish it.
No,
So-
but the
so
first round rounding off was there in your regulation.
Nothing was there. We were silent on that.
Then how?
We only,
So
therefore,
the interpretation of the courts
yes,
based on
based
this-
only on their regulations,
but not NMC regulation.
not an NMC regulation.
That's why Lord Justice Krishna Dixit's
No,
judgment
just that is in our, that inures to us.
The
That inures to us, not to them.
rights of education,
Yes,
medical education are regulated by NMC.
by us.
correct, Lord. That was the law laid down after post 1993.
Yes.
Now, so far as qualifications are concerned, they have left it to the university statutes. Method of valuation, they have left it to the university statutes.
No, no, no.
It's so.
Yeah, no, method of
No, no, no,
valuation, they
that-
do.
far
They do.
from it.
Method of valuation,
This regulation itself, says where we have entered.
correct.
That's our understanding. Standards will be
I think
regulated.
that is beyond, I think my learned friend is not entirely
Correct,
correct
no.
there.
They have said that this is the method of valuation. This is the.
My learned friend can
this is
produce
the
anything
rounding off
which can say to the
Now
contrary.
that has found
we will deal with
interpretation and it is settled.
Now, we'll just come back after lunch. Only 15 minutes to both of you, Mr. Dea, Mr. Chinnappa. We'll just wrap up.
You can finish it off also. That's all.
See, the other matters appropriate would be for each one of you take a date. The court officer will give you a date. We have a specially directed matter. We have to hear that matter also. Okay, that would be better. Okay, all of you just, ma'am, give
Lordship,
dates to.
Lordship, with kind permission, In fact, in serial number 23 contempt matter, it is the demolition, your lordships, wherein the BBMP has come and said that, I mean, they've a portion of a building which was directed to
Can
be.
give you a short date if it
Please,
requires.
please, because it is because of the rain
But
and
it's
all.
not that we are only request to everyone is everyone must not say there is an urgency in the matter.
No,
Then
this
we will
is
be
only
flogging the board.
because of the grave urgency, I'm just seeking.
That's all.
Please.
Let man give the date. We'll give the date. We'll come back after.
Item 22. Madam.
Madam. But court officer. Ma'am, court officer. Court officer, ma'am. Sir.
Madam Haley. Madam Haley, madam. Madam Haley, can you hear?
Ma'am.
ಹೇಳಿ ಮೇಡಮ್ ಹೇಳಿ ಮೇಡಮ್ ಹೇಳಿ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ನಾನು ಮಾತಾಡೋದು
Court officer.
ಹೇಳಿ ಮೇಡಮ್ ಮೇಡಮ್ ಹೇಳಿ ಇದೆ ಸರ್ ಸರ್ ಈಗ ಬೇರೆ ಮ್ಯಾಟರ್ ನಡೀತಾ ಇದೆ ಎರಡೂ ಕಡೆ ಇದ್ರೆ
ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಇಂಡೆಕ್ಸ್ ಡಿಕ್ಲರೇಷನ್ ಆಮೇಲೆ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಇಂಡೆಕ್ಸ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಡಿಕ್ಲರೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಚೇಂಜ್
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ ನಿಮ್ಗೆ ಕೋರ್ಟ್ ಆಡಿಬಲ್ ಇಲ್ವಾ
ಕೋರ್ಟ್ ಆಡಿಬಲ್ ಇದೆ ಮೇಡಮ್
ಮತ್ತೆ ಮೇಡಮ್ ಯಾರು ಮಾತಾಡಿ ಅವ್ರು ಮಾಡು ಅಲ್ಲ ನಾನ್ ಮಾತಾಡೋದು ಅವ್ರಿಗೆ ಕೇಳಿಸ್ತಾರೆ
Court officer.
ಮೇಡಮ್ ಹೇಳಿ ಮೇಡಮ್ ನೀವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅವ್ರದ್ದೇನೋ ಪ್ರಾಬ್ಲಮ್
ಜಡ್ಜ್ ಬಂದವರ ಇಲ್ಲ ಜಡ್ಜ್ ಇನ್ನೂ ಬಂದಿಲ್ಲ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಮೇಡಮ್
ಸರ್ ಹೇಳಿ ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ ನನಗೆ
ಇದು ಬಾಕಿ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಅಡ್ಜನ್ ಆಗಿದೆಯಾ ಅಥವಾ ಇನ್ನೂ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿಲ್ವಾ ಮೇಡಮ್
ಇಲ್ಲೇ ಇದೆ ಸರ್ ಎರಡೂ ಕಡೆ ಕೇಳಿದವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಷ್ಟೇ
ಹೌದಾ ಸೀರಿಯಲ್ ನಂಬರ್ 86 ಅಡ್ಜನ್ ಆಗಿದೆಯಾ
86 ಇದೆ ಸರ್
ಇದೆಯಾ ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್
ಸರ್ ಒಂದು ನಿಮಿಷ ಸರ್ ಫೈಲ್ಸ್ ನಾವು ಕೊಟ್ಟಿಲ್ಲ ಜಸ್ಟ್ ಹಾಗೆ ಇದು ಮಾಡಿದ್ದೀವಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಬರ್ಕೊಟ್ಟಿಲ್ಲ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಏನೋ ಇದು ಮಾಡ್ಕೊಂಡಿರ್ತೀವಿ ಮೇಡಮ್ ಐ ಆಮ್ ಆಡಿಮಲ್ ಪ್ಲೀಸ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ನಿಮ್ಮ ಆಡಿಯೋ ಲೈವ್ ಇದೆ ಮೇಡಮ್ ಪ್ಲೀಸ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಫೈಲ್ಸ್ ಯಾವುದು ತೆಗಿತಾ ಇಲ್ಲ ಸರ್ ಹೌದು ಅದು ಆ ಫೈಲಲ್ಲಿ 465 ಯಾರು ನೆಕ್ಸ್ಟ್ ಇವ್ರಿಗೆ ರಿಸರ್ವ್ ಆಗುತ್ತೆ.
Court officer. Sitting ಬಂದಿಲ್ಲ ಇನ್ನು.
ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್
ಮೇಡಮ್ ಅಂಜನಾ ಅವ್ರ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಟೋಟಲ್ 2 ಇಂದ ಅಂಜನಾ ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತದೆ ಸರ್, ಆಡಿಬಲ್ ಇದೆ.
ಅಶ್ವಿನಿ ಕೆ, ಅಶ್ವಿನಿ ಕೆ.
Court officer.
ಸರ್ ಕೇಳಿಸ್ತಿದೆ ಕೇಳಿಸ್ತಿದೆ ಕೇಳಿಸ್ತಿದೆ.
ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿ ಮೇಡಮ್. ನಿಮ್ಮ ಹೆಸರು
ಅನುಷಾ
ಹೇಳಿ.
ಗೌರವ್ GK 90 ಸೀರಿಯಲ್ ನಂಬರ್ 9091.
ಏನ್ ಬೇಕು ಮೇಡಮ್?
12/8 ಗೆ ಅಡ್ಜರ್ನ್ ಆಗ್ಬೇಕಿತ್ತು ಸರ್. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಅವಾಗೆ ಇದೆ.
ಸಾರಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ನೀವು ಜೋರಾಗಿ ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳಿ.
12/8 ಗೆ ಅಡ್ಜರ್ನ್ ಆಗ್ಬೇಕಿತ್ತು. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಅವಾಗಿದೆ 9091 ಸೀರಿಯಲ್ ನಂಬರ್ ಲಿಸ್ಟ್ 1
99
9091 12/8 ಗೆ ಸರ್.
ಸೊ 90 you want to which date madam?
12/8.
12/8 okay. We'll indicate.
Both the cases 12/8 90 and 91.
We'll note down the date madam. Okay.
Yes sir, thank you.
94 ante madam.
Sir, serial number 69. Sir, serial number 69 adjournment ಬೇಕಾಗಿತ್ತು.
ಸರ್ 18/8 ಆಗ್ಬೋದಾ ಮೇಡಮ್ ನಿಮ್ದು? ಅಲ್ಲ ಸೀರಿಯಲ್ 95 ಮೇಡಮ್ ಇಬ್ರು ಇರ್ಬೇಕು.
Court officer.
31 ಮನಮೋಹನ್ ಶ್ರೀಧರ್ 27 ಅಲ್ಲಿ 2 ಕಡೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದ್ದಾರೆ, ನೀವು ಒಬ್ಬರೇ ಇದ್ದಾರೆ. ನಾನ್ ಗವರ್ಮೆಂಟ್, ಇನ್ನೊಬ್ರು ಇದ್ದಾರೆ ಶ್ರೀಧರ್. ಗವರ್ಮೆಂಟ್ ಅವರಲ್ಲ ಸರ್, ಕಂಟೆಸ್ಟಿಂಗ್ ಪಾರ್ಟಿ. ಅದನ್ನೇ ನಾನು ಶಾರ್ಟ್ ಡೇಟ್ ನೀವು ಕೇಳಿ.
Court officer.
19/8 ಜುಲೈ.
ಆಮೇಲೆ ತಗೋತೀನಿ ಬಿಡಿ.
ಬೇಡ ಇಲ್ಲಿ ಬೇಡ.
Court officer.
ಆಪೋಸಿಟ್ ಅಲ್ಲ, ಅದು ಆಮೇಲೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ, ಈಗ ಕೊಡಲ್ಲ ಸರ್.
Court officer.
ಮೇಡಮ್ ಹೇಳಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 69 2nd July ಬೇಕಾಗಿತ್ತು ಮ್ಯಾಮ್.
ಮೇಡಮ್ 2nd July ಆದ್ರೆ ನೀವು ಕೇಳ್ಕೋಬೇಕು ಮೇಡಮ್, 2 ಕಡೆ ಅಡ್ವೊಕೇಟ್ ಇರಬೇಕು.
ಅವರು ಆಪೋಸಿಟ್ ಸೈಡ್ ಸ್ಟೇಟ್ ಕೌನ್ಸಿಲ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ.
ಸ್ಟೇಟ್ ಕೌನ್ಸಿಲ್ ಅಲ್ಲ ಮೇಡಮ್, ಅದು ನಾಗರಾಜ್
ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್.
ಶಾರ್ಟ್ ಡೇಟ್ ಇಲ್ಲ ಮೇಡಮ್, ಜುಲೈ ಇಲ್ಲ.
ಜುಲೈಗೆ ಯಾವ ಡೇಟ್ ಆಗುತ್ತೆ ಮ್ಯಾಮ್? ಯಾವ ಡೇಟ್ ಮ್ಯಾಮ್?
ಮೇಡಮ್ ಕೋರ್ಟ್ ಕಮೆನ್ಸ್ ಆಗುತ್ತೆ, ಆಮೇಲೆ ಹೇಳ್ತೀನಿ.
ಓಕೆ.
Lord's permit, may I make a mention? That in serial number 77, earlier, my lord, 2 weeks was granted to comply the office objection. Did not comply the office objection, matter was dismissed for default. And I can again to 1 week to comply the office objection. In serial number 77, since the matter was dismissed, the more I am trying to demolish the property which I am staying in. My lord permits me to comply the office objection, my lord, and matter will be taken up.
So we will just show us that. Just say 77, pending hearing of this IA number so and so, comma, the counsel for the appellant is granted liberty to comply with the office objections in respect of the appeal. Re-notify and give it in July.
Permission to serve panel counsel.
See, we don't know anything unless and until you will remove the objection, we will not. How many times are you were given to remove the objections?
One time was given, I was on invasive wakalat.
And there was a preemptory order.
Please.
You don't remove it. You should not. Just remove it. And after removing it, possibly you move it. We will list it.
Please.
Remove it first.
Great.
My lordship, serial number 109, my lordship. It's a mining, illegal mining. There is a many number of people have died on 60 to the.
What do you want?
Blasting.
What do you want?
I need a hard date, my lordship.
Which is the date we have given? Now, what is the date?
109. Short date, my lordship. 215 I asked. Not, short date, no short date.
It's all right. We have told her. See, what is the real urgency? Tell us.
Urgency, my lordship, I am a petitioner. I am the resident. My house is broken. And my neighbors and many people are died. Many people are died because of bomb blasting. 24 hours bomb blasting.
Okay. Okay, we'll have it on 30th of June.
Yes, my lordship.
30th of June.
Much better.
Lordship, may I make a submission, my lordship?
Yes, ma'am.
Serial number 69, my lordship. I've informed the other side. Can I take an adjournment, lordship?
No, we have already adjourned it.
Yes, my lordship. Obliged.
What is the date? Just say re-notify. Who is the other side here?
Is Mr. Nagarajappa.
Just say re-notify on. You have to file, Mr. Chandrasekhar. You are appearing. Okay. Re-notify.
58.
Yes.
Lots of serial number 110. Lots of it's a 2019 termination matter. And
what happened before single judge?
Lots of.
What happened before a single judge?
The matter was dismissed on the sole ground that unless the reason put forward are perverse in nature, the court cannot go into.
We will hear you, Mr. Rath. Are you practicing advocate?
I just completed. I have not enrolled yet.
Doing black coat?
I just completed law.
We will hear you. We will hear you. What is the date given? See, we will hear you. We don't.
It's a covered case.
Just give a date, whatever is convenient. We'll hear you, Mr. Rath. We'll hear you.
The earliest I may.
We will hear you. We have given you a date. We will hear. Just give a normal, whatever is convenient.
18/8.
Your Lord.
That's right.
My Lord, August 15/8.
Obviously. August, convenient. Yes.
Serial number 97, my lords. Matter, I think it won't be reached there. So any shortest possible date may be given. I have informed the other side also.
What do you want?
Adjournment.
Adjournment. At the request of counsel for the appellant. Adjourn to.
14/8.
Shortest possible date.
Pardon?
Shortest possible date.
14th.
Next. May be permitted to make a mention.
48, sir.
Serial
Yes.
number 80, serial number 86, my lords. I'm for the appellant.
Yes.
I was logged in. I heard that it might not be taken up, so I just request for an adjournment, my lords. I've tried to reach out to the other side.
86. What do you want?
Any accommodation may be given, my lords.
I was responding in the matter, lordship. Serial number 86.
Have you given a date? Just say that re-notify on.
My lords, my only submission with respect to this is on the last 3 occasions that the matter had come up before the previous bench, they had undertaken not to precipitate the execution matter till the stay application is heard.
Execution has been filed, Lordship. After filing the execution, they filed the
But
appeal.
you're not precipitating, you're not seeking any execution.
Because there is a direction from the Lordship, I mean, not to take any precipitate action until the disposal of this matter.
Okay, so then we will continue that.
Okay, we'll not take any precipitate action, Lordship.
Just say that
Grateful,
re-notify on, the interim order passed on. Is
No, there was no any interim order,
It's
Lordship.
not in the nature of an interim order, my lords. It was an
Just
agreement.
the observation not to take any precipitation or to
So
take an
we say
adjournment.
nothing, don't precipitate, okay?
Okay.
Grateful, my lords. Very grateful.
Both the parties may be reserved for take adjournment in the commercial, Lordship.
Both of you take an adjournment.
Indeed, my lords. Indeed. Very grateful.
20th August.
Grateful.
Yes, Mr. Chinnappa, come. See, what we have understood is this. There are no regulations of NMC. The only was their decision.
At that point of time with those judgments.
Those judgments. So though the judgments was interpreting the provisions as was brought in by the institute. Okay? And now NMC has come in, stepped in and brought the regulations.
Yes.
Now this is across all the medical colleges.
Across the country. Yes.
Across the country. So what do you say? What has been said?
Yes, madam.
What has been said is only this: the regulations, the whatever they have issued, have been interpreted, which are parameteria to the regulations now brought in by NMC. That's their submission.
That is not
So
in parameter.
interpretation has been given in a particular manner that there is no express bar, that there would not be a rounding off at the second stage. Hence, the judgment is applicable.
My first submission is that there is no parameteria between the two.
What is the difference?
The difference is, let us go back to 98, Marat, the previous page. Ultimately, it is our regulation that is what matters. It doesn't matter if the marks certificate has got one more column there. If it has a column, grace marks. It doesn't matter. If the regulations say that there shall be no grace mark, there will be no grace marks added in that column.
So, very well. That argument is here based on the previous judgments.
True.
Rounding off percentage is not similar to rounding off or granting grace mark. That's all.
That's all.
We have put it to him. The rounding off percentage shall have the effect of marks getting increased, which he says no.
Grace marks.
Which he says no. That's the
That's
interpretation in the
that's their
judgments.
interpretation. That's the interpretation of the learned single judge also. And the answer to that is that that does not amount to rounding off, does not, in fact, indeed amounts to grant of grace marks.
That's your submission.
And for the reasons which we have already discussed to an extent, but to be a little more focused on that in response, I will say about 3 to 4 points I need to answer in response, Malot. The first one would be, when that portion is read on page 98, when the theory dash aggregate 50% in addition, as if to impute that no, it is still the whole 50% as a percentage. No, we have made a conscious effort prior to that to do two things. One is, let us go back to 8.4b, where, as my lord already asked them to read that, and I'll read it again. There is a conscious attempt there to say that there is a rounding off, indeed, to be done. So when there is an express provision in a regulation which says something is to be done, and it stops at that point, that means nothing more and nothing beyond. That is my first submission on that point. The second submission would be, as we go further, we have made a conscious effort here to say that beyond that rounding off, there shall also be 200 marks. We specify the marks. We have not left it to a percentage. We have said you shall get 200 marks out of 400. Therefore, we are conscious of the fact that every time a mark is given, there is always a half mark or a quarter mark or a 3/4 of a percentage point. it always happens. And that is the reason consciously we did that. And when we accumulated this over here, we have already done all the rounding offs. Having done all the exercise of rounding offs before that, provided for it, then we come flat and say it is 200. Otherwise, if that were not so, what would have happened is we would have said, add your, in that chart, I'm passing this colored version for my lord, so that my lords may keep that. The distinction becomes a little apparent. And in that same column, my lord, please see that 200 upon 400. Not before that, just a moment. On page 98, 200 upon 400, when we have written the numbers there consciously we did not write the 50% there. We only highlighted that, remember it, that you also have to get 40 individually in each of the 4 papers.
You know what is being said? On a rounding off principle,
yes,
there is no increase in mark. Marks are what they are, like 49.25 or 49.50. It's a sort of a discretion which has been conferred on the authority. Though marks are equivalent to 49.50 or 49.75, but in your discretion, you make it that 49.75 as 50%. There is no enhancement in marks per se, even in rounding off.
No, there is.
How?
Without that, there cannot be, when there is an increase, there cannot be, for this reason, that aggregate of 50% is happening only because marks are being given.
Okay, if that be so, you have given rounding off in the first round?
Yes. Yes.
Did you increase the marks?
Yes.
You increase the marks.
Please see the chart. That's why the colored chart has been forwarded now once again. Please see what is the extent of increase. Now I will not only show, my lords, I will show per student how much it is increased.
Okay, so 46.5 became 47.
Yes, not only that, please see the first one. In an individual paper by an individual examiner, 2 rounds of enhancement, 49.5 became 50. Thereafter, 2 evaluations. The difference between the 2, that also got averaged. So there is an enhancement first. Please see the third example, blue. 1, 2, serial number 3, writ petition 3539, 49.5 in a paper by an evaluator is rounded off to 50. Thereafter, 50 and 39 together add up to 44.5. That again is rounded up to 45. Therefore, 2 rounds. And to understand the scope of the extent of marks that are given, please take that column, but go backwards, 3rd column from the end. For every student by this method, and we are talking about students who have failed, 4 marks, 3 marks, 2 marks, 7 marks, 5, 3, 6, 5, 6. This is the total extent of the marks already given by virtue of rounding off, and yet they have failed. So it's not, it has a multiplier effect. As my lord had seen, when A and B were shown to my lords, when A and B were shown, A had 0.5 everywhere. Grand total was 198. At one point, my lord did ask the question, there was a poser, what is the total? That was not answered. The total would be 196. And the percentage of 196 would be 49. So you wouldn't be in a position to even ask for a rounding off. And that is only one stage of rounding off. Forget about the first limb of rounding off, when every individual evaluator's paper was also rounded off. That's why I've given those 5, 6, 7 marks each candidate getting that much. And the B part of it, when it was sought to be it was sought to be shown that by virtue of that, a person who has got more marks has also failed. That was not an appropriate way to put it. That's the least I would say. But I would show just one contra example. If a person had got 39, 39, 39, they would not have passed with 40%. Yet, getting 90 in the fourth paper, they would have got 207, yet they would have failed. Because it says 200 upon 400, bracket 40% per paper. Now, it would be said, no. In this particular case, you've given an example where it is, it's 39. Notwithstanding that, let's make it 40. If we still make it 40, it will be 204. If it comes to 204, in that event, the person passes. So the examples that are being given are not really appropriate to the and the extent of marks that are, and then the 2 points that were there with regard to the 2 judgments. Page 15 was one judgment which was cited, my lord. That particular judgment, my lord, may kindly see. There is a highlighter there in the judgment itself, my lord, where my lord mentioned it itself. It fell from the court itself that if the rules or provisions specifically otherwise provide, my lord already said that. Therefore, that is the distinguishing factor in that. So it cannot apply there. And then going back to page 49, my lord, the judgment that the portion that was referred to, my lord, there, that page 49, that portion goes against them, because there they say, so the contra would be true. They say that what they say is, however, the golden rule of interpretation is that the interpretation of a provision should be made in a manner, especially in such cases, keeping in view the objective of the beneficial legislation. The marks legitimately obtained by a student cannot be taken away. So there, the concern was, you cannot reduce it by 0.25. But if you go back to that other judgment, which was read, the last judgment at page 93 or something, which said, you have to ignore the portion which is less than 50. That is again a 3-year judgment. So the third judgment, so we sometimes would feel, I was also feeling that, my lord. That's why when the judgment was pointed out, I said, that 0.25, you eschew that. That's the judgment of the Supreme Court. We say eschew that. That is why when we said that it should be the nearest integer, so that has to come in that particular fashion, because again, it's a beneficial thing which is multiplied twice over. And then coming to this, here they say you should not take away. Here, percentage again was involved. Numbers were not mentioned specifically that it will be 200 upon 400. So when it is specifically mentioned 200 upon 400, there's no scope for taking away or giving. It is not a case, and I repeat this, my lord, it is not a case where all these figures, as my learned friend Sumana had said, if it were from the beginning, we had started our journey with, which she made an attempt to hint at that, but it would cut against them. 45.5 in the first round with one examiner. I would not average, I would add all of them. I would move forward to the total, all 4 in, I add all of them in decimals. Then undoubtedly, I would say without hesitation, you have to round it off. That would be at least the least fairness you could do. But then they would lose out, because here they got the benefit of, as we have seen, 2 full marks by virtue of that at the second stage in the example that was pointed out. So it cannot be by any stretch of imagination, that cannot be. And the last part of it, which was there, where we said, no, we are trying to cross and become eligible. I repeat, it is not a question of eligibility. It is a question of testing whether you are able or not. Don't say it makes you eligible for the next step. Whether you are good enough for where you are. That is the distinction I was trying to make when I gave the 3 examples there. So the candidate and the athlete who does it, that athlete performs on the bar. They get 9 out of 9, 9.5 out of 10, whatever they get. Yet, it is only that which counts for the athlete. Yes, they are also competing with others. All these fellows are also competing, students are also competing with each other for the gold medal. Yes. And then subsequently. But the first test here is, are you up to the mark to be said that you are a postgraduate? Don't talk about eligibility yet.
We put it benchmark.
Pardon?
You have to reach that benchmark.
Whether you reach that minimum benchmark. That I am at that stage yet. They are presuming that once I get this, I'm eligible for the rest.
No, they may get an eligibility for the specialist.
That is consequential.
It's consequential.
Somebody may want to go, somebody may not want to go. I want to know as the regulator whether I should let loose them on patience, my lord.
Their anxiety is the only thing. Once we get in eligibility, we may compete there.
True. That is the anxiety. I respect that.
Yeah, Mr.
But
Chinnappa.
but our point is that we are only concerned with the fact that whether we should be as regulator.
Got it. We got it. That's a totally a fresh consideration. This is only eligibility.
But you have to pass here. But you have to pass here. You can't go without passing.
Pardon?
Yeah, give me a copy, please.
Oh.
Two copies. Here's the third copy.
Yes, Mr. Chinnappa.
My lord, I think when we appear on this side, my lord, we sound very inconsiderate because we are arguing against a student and we are arguing for 0.25 and 0.5 and 0.75. Therefore, in a way, my lord, all the others may complain that we are really being inconsiderate to them only for less than a 1 mark or 1%, so to speak. But really, in my respectful submission, someone somewhere has to draw the line. And the regulations draw that line. The regulations draw that line on the basis of marks, not on the basis of percentage. Percentage is a consequence of the marks. Therefore, in any testing scenario, you don't test the percentage first. You must first achieve the mark. The mark may result in a particular percentage. Therefore, whatever rounding off should be done has to be at the mark stage. It can never be at the percentage stage because it is only a reflection of your marks. It is nothing more. And therefore, my lord, for them to argue that no, you must round off the percentage is to ignore the marks. Rounding off can only be at the mark stage. Respectfully, the earlier judgments of this court may not even be correct in that sense in rounding off a percentage because it can only be rounding off a mark. And as my learned friend pointed out, when you round off a mark, actually the maximum benefit the student can get is about 2 marks. Because if he gets 0.5 in 4 subjects, it rounds off to the higher mark, which means he gets 2 more marks. So a person who got 49.5, 49.5 actually hits 50 simply by rounding off. And he gets 2 more marks, which means well, you've got 1 benefit there. And then you say, again, give me another benefit at the end of it to increase my percentage from 49.5 to 50. That will not, in my humble submission, may be a scenario where you're giving not only a rounding off in the first stage.
That means, are you rewriting the first, the benefit which you have given? So rounding off is to the next integer.
Correct.
But if the percentage also get increased, it will go beyond that.
Yes, it will.
It will go beyond that.
So
it will go beyond 50.
It will go beyond 50. Therefore, a scenario where someone has 49.5 in all subjects, automatically he's become 50. There's no difficulty. But someone may have 48.5, 49.5, 52.5, which may all round off to 49.5, which is what happens in a case like this where you've got 198 marks. Very close to 200, but you're 198 and therefore you only will get 49.5. That 49.5 is not your marks. 49.5 is a reflection of your marks in percentage form. There's nothing more, which is why, my lord, the NMC regulations make it very clear that the rounding off is permissible only at the mark stage. And that's it. After that rounding off, whether you take it as a grace or otherwise, the second rounding off does not arise. Second rounding off is only to tell you what percentage you've secured and nothing more. Therefore, in my humble submission, this entire approach, whether in the earlier judgments or now, my lord, in terms of this regulation, in my respectful submission is incorrect. Because it is practically doing it twice. And the second time, the resultant effect is an increase of 4 marks. At the worst. Yeah. And at the best, my lord, 1 mark. So someone who has got 49.25 actually may have been subject to a rounding off by virtue of which he got 3 marks more already. So he'll get another 3, making him 6 marks more than any other student. That is unfair to every other student because everyone writes the same examination. Some pass, some fail. I mean, that's a fact of life. We can't help it. And therefore, to try and alter the regulations by interpretation, in my humble submission, is incorrect. Secondly, when the regulations themselves make it mandatory that no grace marks will be given, except for rounding off. Therefore, they made a distinction there, saying you can't give a grace mark. The second, what they are asking for on the overall marks from 197 to 200 is actually going to be grace marks. Therefore, it is, in my humble submission, impermissible to do a percentage-wise rounding off, you must only do marks wise. If marks wise rounding off results in 200, like 199.5 my lord results in 200, it can never happen because you've already rounded it off. But if the rounding off has resulted in 200, you've passed. But there can't be a second one. The second point, my lord, is I was looking at the earlier regulations, which I'll just pass it on to your lordship. On examinations is at 14.
The clause 4.
No. Clause 4, my lord, is in our ordinance. This is the regulations of the NMC, the earlier regulations.
Which year?
This is amended up to 2018. 2000.
After that, you didn't make your regulations. Or the 2018 continued?
2018 continued. They amended.
2023 new regulation came.
The regulations
From
of 2000
2000 to 2018, earlier regulation was there.
So this 2000 regulation continued till
Till
when?
23.
Oh, till 23.
Till 23.
Now tell us one thing on the fact that they have brought in regulation which were in force. How could you have issued clarifications or a decision?
On which?
The institute.
The university.
University.
On which issue?
They had a regulation.
Yes, yes.
The field was occupied.
Yes.
But then how you could have issued?
We made an ordinance for the COVID period. For the COVID period. Actually, my lord, my clarification is only for the COVID period. And in that, it only provided that during the COVID period in 2000.
But that's permissible for you to do that.
No one tested it. No one tested it.
Or no one objected to it.
No, everyone, it was.
That is the correct expression, my lord, because of the circumstances. Nobody wanted to take.
No, it benefited. The only ones who could challenge it are the students. And the students benefited, therefore no one challenged it. Your lordship is right. I don't know if it can really be justified.
And that was across all the universities.
No. Only
this is a state university.
State. Rajiv Gandhi University.
This is
For
state
health science.
university.
State. Karnataka only. It's only Karnataka. Karnataka.
All affiliated to this.
All the medical colleges affiliated to the university.
Okay, let's not go into that. Now, that would be an endless argument.
Yes, it is.
Yes.
Now, examinations in these regulations don't provide either for rounding off in any form whatsoever. There was nothing enabling, nothing disabling. All it said is the requirement of 50% marks. That is clause 14, my lord.
You are reading 14?
14. I looked at it with all the amendments. I can say, my lord, there is no provision of the kind that is there now in the NMC regulations which are before my lord.
So you're saying there was no rounding off at all?
There was no rounding off. There was no grace mark. There was no mention of either.
Okay.
50%. And the requirement, my lord, was 50%. There was no marks stated or stipulated in these regulations.
All the reference was to the percentage.
Obtaining 50% marks in theory as well as practical. Therefore, the focus now of the NMC has been on marks. And no grace mark, rounding off at the subject stage, not, my lord, at the total stage, at the final total or cumulative score. There's no rounding off at that stage. That is a fundamental distinction, if I may say so, between these two, my lord. And therefore, respectfully, any other interpretation which has been taken in the context of our regulations or, my lord, or our ordinance and these regulations which were there in the past will have, in my respectful submission, no impact on an interpretation of the new ones, which I would respectfully say are covered by the judgment which I placed before my lord. Now, my lord, one judgment which my learned friend, I think Mr. Vivek Reddy pointed out at page number 62, seemed to suggest on rounding off. Lordship may kindly see one judgment of the division bench of the High Court of Bombay at Nagpur, which extracted a 3-judge bench judgment of the Supreme Court on rounding off. I got that judgment not to see how it was relevant, but it's strikingly relevant.
Yes.
Page 63 is that judgment. I'm sorry, your Lordship has a compilation. Yes, page 63, para 6. I think my learned friend referred to para 6 to say.
Right, para 6.
Yes. We do not find any fault with any of the two reasonings adopted by the High Court. Rule of rounding off based on common sense and logic. If part is 1/2 or more, its value shall be increased to 1. And if part is less than half, then its value shall be ignored. And 46.5 should be rounded to 47 and so on. This, my lord, was interestingly in the context of reservation percentages. So there were a certain number of posts. How much would be the percentage after rounding off? That was the question. So how many posts had to be reserved to scheduled castes and backward tribes was the question. It was coming to 46.5. High Court said make it 47. There's no marks, nothing of that kind. We pass it on. This is the judgment.
See, the intent is there is an eligibility condition. The gentleman could not reach that eligibility condition. He just is slightly away from it. Just give a little bit of discretion and ensure it he goes and reaches.
I think not all the orders that your lordship has seen from our High Court is based on that principle of sympathy rather than any rule of law. It has been he's come so close by judicial interpretation. Let's push him forward.
Yeah.
Innocent side, other sides. Page 10.
Very interestingly, also we have seen in service rules, you know, a person, I've seen at least in the context of a person who has completed 10 years of service, 10 years of service, he gets pension, you know, if he retires in a normal circumstance. Someone who is short by more than half, it's like he has completed 9.5 years, but between 9.5 years and 10, they say then you do one thing, you give that rounding off and ensure it he gets the pension. It's only to say that he has not reached eligibility, but he is very close to it. Let's give them discretion and make it eligible, make him eligible. That's the intent.
That's been the intent, Lord. And I think, quite honestly, all the orders were ultimately to try and see some benefit to a student who's come. But I would respectfully say, whether judicially or otherwise, now there is a clear rule. The rule makes it mandatory that you must get the certain mark which is fixed, which is why I said the percentage is simply a reflection of the mark. It is not by itself a guiding factor. And therefore,
consider everything,
yes,
whatever you have argued. Thank you.
I think I'm so sorry. One argument my learned friend made was that these regulations will not apply. The 2023 regulations will not apply to this exam. There's a clear clarification from NMC itself, which says that these regulations will apply to the examinations. All examinations conducted after 20.
Sure, was issued by the university, not by the NMC.
No, 2000 regulations was issued by NMC.
The regulations are in the nature of prospective, because the regulations is not just about the examinations. It's a whole composite of what is the course, what are the new degrees, what are the requirements of the degrees, what are the structure, everything. Yeah, please. So that is a whole structure which is prospective in nature. By no means, in no ambiguity or such thing does it make it applicable to the previous students, because we fall under the old one. We've studied under the old system. We are in fact called also categorized by the university as a separate category of students.
I don't know.
There's not the High Court itself answering this.
They have not. In fact, it is answered.
How far that argument would be?
Let's not go into that.
Lordship may just see it.
Just show us, ma'am, that.
One second. Wait, just 1 minute. Sorry.
What is this?
This is the question we asked, my lord, as to whether the new ones will apply or not. So we got an answer. I'm ready to refer so and so. It has already been clarified in the public notice at 10/4/24 that this.
Regulations.
1 minute. This regulation will be applicable for all those students appearing in the forthcoming postgraduate examination. Hence, PGMR 23 will be applicable to all those students who appeared for the examination since its notification dated 29/12/23. That's the clarification of the NMC as well. No one.
Of your compilation?
Yes, which we produced. Remember, Lord, the Delhi High Court judgment. At the end, there is some interesting observation. Reference to a Himachal judgment and what Supreme Court, how Supreme Court dwelt with it.
Yes.
Yes. Lord, division bench of page 19, para 6, Lord.
Yes.
The division bench of the High Court of Himachal Pradesh has also relied on principle laid down by the Honorable Apex Court and High Court of Hyderabad versus Murali Mohan Reddy, where it was permitted, where that rounding off was permitted. We are thus faced with a situation where the respondents could not secure qualifying marks as per the judgment of this court. However, a close scrutiny of the marks obtained by the respondents would disclose that the two candidates, namely so and so, have secured so and so as against the marks required of 100. Insofar as so and so, Sunita is treated as 100 marks. Since S. Sharda Devi is also short by 0.7 marks, there is no reason not to round off her marks to 100 as well. Going by the consideration, they have not been working as ad hoc judges they have been working as ad hoc judges for a number of years. And also the fact that it was only a qualifying examination for the purpose of regularization. Kindly see the distinction, Lord. Qualifying examination for the purpose of MD course is different from what I get in NEET for qualifying for the purposes of future admissions and employment. These are totally different criteria. Then, therefore, these two candidates or respondents have to be treated as qualified the written test and interview with their marks so and so. With the aforesaid observation, considering the principle laid down by the apex court in the aforesaid judgment, it was directed the response to round off 39.29 marks secured by the petitioner therein to 40 marks or grant him 3 grace marks so that he is declared to have qualified the test in question. Feeling aggrieved by the said judgment, AICTE filed SLP number so and so. It was interesting, Lord, what happened in the SLP. A similar view was taken by the High Court of Uttarakhand and so and so. Now, Lord, kindly come to the conclusion portion. In view of the aforesaid discussion, this writ petition is disposed of directing the response either to add 1 mark or round off 39.76 marks secured by the petitioner to 40% so that he will be declared to have qualified the test in question, validation examination. With the aforesaid direction, this writ petition is disposed of. Now, Lord, kindly see para 35. It is thus seen that with respect to the same examination, 34, Lord, under the same facts, 3 high courts have already considered the rounding off of the respective candidates. The respondent AICTE, acting upon the directions given by the concerned courts, has held the candidates to be qualified. Therefore, there is no reason to deny the same relief to the petitioners. It is also to be noted that even in the case of Kanai Lal Sharma, the decision of the High Court of Himachal Pradesh has not been interfered with by the Supreme Court. However, the question has been left open. The order dated 28/7/20 passed by the Honorable Supreme Court reads as under, in the peculiar facts and circumstances of the present case, we see no reason to exercise our discretion under Article 136 of the Constitution and interfere in the matter, especially if petition is dismissed, leaving all questions to be left open. It is undeniable that
36.
Yes, the petitioners are already under employment for more than a decade. There exists no allegation on the part of the petitioners. Also, the respondent AICTE has not indicated any rule regarding this examination which bars the candidates from claiming the benefits.
This is the basis for the earlier judgment.
And now, Lord, another interesting feature, if your lordships would see that 200/400, that page, Lord, for a moment. Kindly see that 200/400, 96, 98,
Yes.
90, 98. Just glance at that page. Very interesting. Kindly see, much as we have argued much, Lord, on the point that what happens if there is no regulation on rounding off, prohibiting the rounding off. If there is nothing to prohibit the rounding off. This seems to indicate that position. Now, Lord, kindly see in that first above practical, passing minimum for theory, 200 out of 400, 40% minimum in each paper.
That's what we have put it to him.
Yes.
No, but yeah, right.
But kindly see the down below, Lord.
See, but tell
Theory
us one thing.
aggregate 50.
But this 200 out of 400 signify 50%, not 40%.
Correct.
This 40% was out of context here.
Out of context. Now, Lord, your lordships are right. But kindly see where they specify aggregate 50% below. There they should have said minimum. If they wanted to oust the rounding off, they have to specifically oust the rounding off. What they have done, kindly see, Lord, 3:1 theory, aggregate 50%. They have not said minimum 50%. If they wanted to oust the rounding off, the regulation should have specifically said so. Then it would have made a difference from the previous, which the division bench interpreted. Now we are on same parameter situation. And it would be difficult to say for the university, at least, it would be difficult to say for the university, after having lost the litigation in single benches and division bench, 2 division benches, to come out now and say, and after having accepted the previous judgment, which said it is without irrelevance of COVID, without relevance to COVID, this is there, it stands. It is very difficult for them to argue today. It's all doors are shut for them.
No.
Because they have accepted the division bench, they did not take it to the Supreme Court.
Thank you.
Two sentences.
No more, not one a single sentence.
Quickly on the point, I won't repeat it, Milords. Just 2 points. Milords, the argument that was raised was the earlier judgments were interpreting the Rajiv Gandhi University's regulations and not NMC's regulations. Absolutely, my lords. What NMC has now done is incorporated the very same wordings under the Rajiv Gandhi University, which was interpreted there, is now in the regulations. So all the more, my lords, the judgment applies now in terms of, my lords, the judgments. That's one, my lords. Second argument that was raised was, my lords, that the grace marks are not permitted under the new regulations. So you cannot award these marks, is what is the argument. If that is so, the regulations which are there now incorporates rounding off. So rounding off as a concept is not considered as grace marks by NMC itself.
It's
So
not alien.
It can't be said at the same breath under the same regulations that rounding off is not permitted, grace marks is not permitted. They are permitting rounding off and they say grace marks are not there. So rounding off cannot be considered as grace marks. That's what the learned single judge also has said in my judgments, that rounding off cannot be considered as grace marks. That's all.
Thanks.
Please, oblige.
And this is contempt. This is separate. This is separate. This is separate. This is mine. And this also. Thank you.
Please oblige for the patient here. Please.
Thank you. Yes, Mr. Chinnappa, come. Ma'am? All matters adjourned, ma'am. Yeah. How many are there? That's all. They were not there.
May I make one request? I have serial number 80 as well before your lordships. There is some grave urgency in that matter. It's a matter where I have succeeded in the arbitration. Yeah, I have succeeded in the challenge under section 34. In the 37 before this honorable court, they made an oral prayer at the bar for a status quo order. I tendered it's relating to my property which they had taken on rent. I have already rented those properties out to 2 other parties. And status quo order, my leases were taken on record, and the honorable court granted a status quo order, which actually protects me because my tenants are in possession. Using that status quo order, they have prevented my tenants from proceeding with renovation of the property. They have harassed them to the extent where they have terminated those leases today and are threatening to leave. This is a property which I have not made rents for the last 4 years, and they have delayed the execution proceedings. Today they are sitting protecting that property, preventing me from using it and extending the status quo and misusing it. This has been the state of affairs since 19th of March, my lords. Today a date was given, so I did not move for an earlier date, but it's unlikely to reach today, so I would request the earliest possible date.
Who is the other side?
Mr. Pramod Nair, senior advocate, appears. Any date your lordship grants, I will inform them immediately.
Date, ma'am. Re-notify all. We will have it somewhere in, may go in August.
My lords, this is the only problem, my lords. My property, I am bleeding. I am not allowed to use my own property because they are misusing a status quo order of this honorable court.
We'll see it in August. Next. We'll give a date.
Could it be at least in July, my lords?
We are clogging the board. It's not possible.
The only reason is this, my lords. I will not find tenants again once they leave.
We'll see it. We'll see it.
7, 8.
7th of August. Next, shall just call them. Yes, Mr. Chinnappa.
113.
So you have 20 minutes. That's 20 minutes.
I'm conscious, my lord.
And we will overshot 4 o'clock. So we will reduce it by 15 minutes. We have fixed a bench at 4 o'clock. So
Yes, I know. I'll stay by that promise. I'll very briefly summarize what I'm saying. The written submissions are ready, but it has all the judgment. That's why it's bulky, my lord. Kudos. There is a entity called IEEE, my lord, which is actually an Institute of Engineers. Now, the Institute of Engineers is a global organization which supports engineers throughout the world. So IEEE has various chapters in various parts. A direct subsidiary is us, that is, my lord, the appellant, called Global IEEE Institute for Engineers. It is an undisputed fact, my lord, that we entered into a contract with the defendant, IEEE Mumbai section, as a service assistance agreement, where, my lord, we were providing service, we were providing them money.
They also call them EEE.
IEEE, they're also IEEE Mumbai section.
It is based on after your contract.
They had it earlier itself.
Here itself.
Don't worry, I won't. My learned friend is very eager in this matter, so they had it earlier itself.
Are they independently claiming a right?
No, now that's the interesting part. Now, of course, they may try independently claiming a right, but that right is subordinated by contract. Because there's a contract entered into between us, whereby we license them the use of the mark, IEEE, and then on that basis, they've continued. Therefore, whether they had a right previously or whether they had a right earlier is really of little consequence in my humble submission, because they subordinated whatever right they had by entering into a contract and taking a license from us. Therefore, they clearly accepted that this is a license, because ultimately nobody can deny that IEEE is a brand owned in the United States of America by this entity, and who has thereafter ensured, because they also depend in a significant way on the funds that we provide them for the purposes of ensuring that they can develop various processes and products and things of that kind. Therefore, it is a case where we are actually providing the money and also the right to use the brand. That's underlying principle. There, my lord, we found that there was a lot of violation by them. And because they were required under the contract to provide us accounts of how the money is utilized, they refused to provide accounts, which finally led to a repudiatory breach on their part, which therefore resulted in termination of the contract. And therefore, we terminated the contract. After we terminated the contract, we called upon them to cease using the mark, IEEE. To which, my lord, there's some correspondence saying, no, don't do that, and we will discuss and do all of that, but didn't work. Finally, we filed a suit, and an injunction was granted by the trial court, which, of course, my lord, they did not comply with. That's a different matter. The jurisdictional clause, my lord, is in Bangalore under the contract. We sued under the contract saying, there is a right granted to you under the contract. That right has now come to an end, and therefore, since the right has come to an end, you cannot continue. A declaration first that the termination is valid, and secondly, a consequential injunction to restrain them from using the mark. I'll tell you what is where they're trying to argue. The word infringing is used in that paragraph, but really it is only a consequential relief of an injunction. Because the word infringing is there, they say, oh, it's an infringement on trademark. Really not an infringement of trademark, because when your lordships look at the various paragraphs in the plaint, it becomes evident that I'm claiming a right under the contract and nothing more. And I'm making a statement also to the court that I'm not making any claim under the Trademarks Act. So which, my lord, they filed a written statement and an application for rejection of the plaint. The application for rejection of the plaint was predicated on two grounds. The first ground was that I am a trust in Maharashtra, and under the Maharashtra Trusts Act, you should have obtained the permission of the Charity Commissioner before you sued me. That was the first contention under section 50 and 51 of the Maharashtra Trusts Act. The second argument was you are not a registered user by registering yourself under the Trademarks Act, and therefore you don't have a cause of action to sue. So the second argument was on cause of action. The first argument was on a bar, on D, and the second one was on B. The trial court said there is no question of cause of action. Cause of action exists, and therefore rejected that argument first on the argument on Trademarks Act. The second argument was on the Trademarks Act was rejected. The first argument,
So it accepts it is a right under the contract.
it accepts it's a right under the contract. As a matter of fact, there's an earlier order as well, treating it as a commercial dispute. There also it says it is a right under the contract, and therefore you are entitled to sue. The second is the argument with respect to 50 and 51. If your lordships read the order, till the end it seems the court is in my favor. But at the end, there's one small difference that the court makes. I'll just read that much, my lord, and then I'll show you lordships the law. The appeal memo. Your lordships may kindly take the appeal memo.
Which page?
Please come to page 85. And where the court went wrong is in this paragraph itself. Para 15. In the present case, it is the allegation of the plaintiff that the defendant association has made use of the mark IEEE knowing fully well. It is owned by the plaintiff and has continued its breach even in the existence of an interim order. Specific allegations that trustees of the defendant trust are making illegal use of the trademark by infringing the mark, causing wrongful loss to the plaintiff. And also the plaintiff is seeking damages to be paid by the trust or the defendant association for having infringed the trademark owned by him. Though the plaintiff has claimed it owns the trademark, relief sought against the defendant is to restrain the defendant public trust from using the mark and also to direct the defendant public trust to pay damages for infringing the plaintiff trademark. Cannot be termed, it is not termed, it's termed, cannot be termed as a private or individual right to the plaintiff. The plaintiff is not a single individual, but it is a private limited company under the name Global IEEE Institute for Engineers. It is an institutional right which is being canvassed in the present proceedings, and it cannot be termed as a personal or private right to the plaintiff. In the decisions relied upon by the learned counsel of plaintiff supra, the private right of the individual or subject matter of the suit, with respect to having observed that no public right was involved, the requirement of written consent by charity commission was not required. On the other hand, in the present case, there is no individual right assigned by the defendant. Allegations that members of the trust, which includes many members, who have continued to infringe the alleged trademark of the plaintiff, and therefore for the suit of the nature prior written consent of charity commissioner, as contemplated on 51 of the Maharashtra Public Trusts Act, is mandatory, and without which plaintiff's liability rejected is barred, and hence barred. Therefore, the right, my lord, which I claim under the contract is termed to be an institutional right because I'm a company. And on that basis, the court says you should have taken the consent or the permission. But really, my lord, the entire provisions 50 and 51 are relatable only to the management of the trust.
The right which you got is on the basis of assignment.
No, not assignment. I'm also on a license.
You also have
I have a license.
license.
A license. It is a license granted to me, my lord, and mine is a sub-license to them, or a permission for them to use the mark. This
Only license.
only license. It is
Okay.
the concept of a registered user is referable only in a scenario where I'm suing for infringement of a mark where there's no contract. As a registered user, my lord, if someone infringes the mark, I can sue directly without and make the owner a defendant. I don't have to actually wait for the owner to come. That is a context where there's no contract, where I'm suing someone for infringement of a mark. As a matter of fact, the Trademarks Act uses the expression permitted user also. Permitted user has all the rights of a user, of the owner of the mark, but he cannot sue for infringement. A permitted user is not registered, but really, I'll show you lots of one direct judgment to the Supreme Court, which says it is part of the common law right to license. It is not part of the law of trademarks or a statutory right. The difference, therefore, is when I sue for infringement, I should be a registered user. Now, of course, Delhi High Court has said that even if you simply made an application, because those applications take 10 years to be granted, you can't wait for 10 years to sue. Filing of an application is sufficient. But I'm not a registered user. The common position for all of us is we are not a registered user. We are suing simply on the basis of the contract. And that's it. Here the finding is because you're an entity, therefore it is an institutional right. And if it's an institutional right, it stands differently from a private right, and my humble submission is wrong. A right is under the contract. That is a personal right which I'm suing. And therefore, what is in a public charitable trust? If
Why is that permission required in the
now section 50, Lordships may kindly take section 50. I have filed one compilation which has the Maharashtra Trust Act.
The intent would be under 51. No? What is the intent?
Yes, intent. That is answered by a judgment of the Supreme Court directly on that issue. Lordships have 50, I had actually given a small compilation. This has a compilation which has the Maharashtra Public Trust Act in the beginning.
Yes.
Filed by them. Yeah. Oh. I think, my lord, they have filed this compilation. Oh, I see. It has the Maharashtra Public Trust Act on the top.
Yes. He had just.
Yeah. Please see section 50, my lord. in any case where it is alleged that there is a breach of a public trust, negligence, misapplication, or misconduct on the part of trustee or trustees, where a direction or decree is required to recover the possession of or to follow a property belonging or alleged to be belonging to a public trust or the proceeds thereof, or for an account of such property or proceeds from a trustee, ex-trustee, alienee, but not a person holding adversely to public trust, trespasser, license, or tenant, where the direction of the court is deemed necessary for the administration of the public trust, or for any declaration or injunction in favor of or against the public trust or trustee or trustees or beneficiary thereof, the charity commissioner, after making such inquiry as he thinks necessary, he can file as well. Or two or more persons having an interest in case a suit is under subclauses 1 to 3, or one or more persons in case a suit is under subclause 4 having obtained the consent in writing of the charity commissioner as provided in section 51, may institute a suit where the contentions are not in the court within the local limits of whose jurisdiction the whole or part of the subject matter of the trust is situate, or to obtain a decree for any of the following reliefs. That is, order for recovery, removal of trustee, appointment of trustee, vesting any property in trustee, direction of taking accounts, directing that is for misfeasance, declarations of what proportion of trust property of interest shall be allocated, direction authorizing the whole or any part of the trust property to be let, sold, mortgage, settlement of a scheme, order for amalgamation, order for winding up, order for handing over one trust, order exonerating trustees, order varying, altering, superseding any instrument of trust, declaring or denying any right in favor of or against public trust or trustee or trustees or beneficiary, and issuing injunctions in appropriate cases. These relate ultimately, my lord, to the management of the trust. And why it is so is, if your lordships now kindly come to section 52. Oh, I'm sorry, your lordships don't have the book. Oh, may I pass on the book when I have another book? Yes, I have a book, but I thought this you had filed it, no, last time?
We had filed a compilation of judgments.
Yes.
It is not relatable to the right of this entity.
Yes, yes, it is.
Under the contract.
Under the contract, which is what has been examined.
Just take that.
Yes. Answer. I have two books. My lordship may have not this book.
One is sufficient.
Lordship.
Yes.
Please see, my lord, 52. Notwithstanding anything contained in the Code of Civil Procedure, the provisions of section 92 and 93 of the Code shall not apply to public trust. Now, Lord knows 92 is a proceeding in public interest. It is instituted after permission is obtained of the court or of the Advocate General before you proceed with the suit in order to really institute a scheme for a trust which is being mismanaged. This entire provision is really a replacement of 92. The objective, now Maharashtra Public Trust Act have been interpreted in Maharashtra and Gujarat quite extensively. There are one set of judgments saying it cannot be a ground for rejection of plaint. That is one set of judgments. Then Supreme Court has examined this very question, interpreting section 50 and 51. Once we come to persons having interest, give me the judgment. Lordship may kindly take that written submissions which I gave your lordships. It has the judgments here. Where is it? Oh no. Vinayak versus Shivram. Page 65. Vinayak versus Shivram. Para 13 at page 73. Here, my lord, an hereditary right as Archak of the temple was claimed. The hereditary right as Archak. Para 13. Please see how the Supreme Court dealt with that issue. What is to be seen, my lord God, is the relief the plaintiffs are seeking from the court. First of all, they are seeking a declaration about the hereditary rights as Archak of the temple. My lord, yeah.
Yes.
This right is claimed in their personal capacity as a family of Archaks who have been performing the functions of Archaks since the day the temple was established and the deity was consecrated. It is a different matter whether ultimately the plaintiff's contention is accepted by the court or not. Surely the plaintiffs are entitled to have their claim examined by the court. If they fail to establish their claim, they'll be out of the court. However, if they succeed in establishing the claim, they'll be entitled to the declaration sought. That they cannot be non-suited at the threshold unless the suit is expressly barred by any statute. We have seen the provision of section 50 of the Bombay Trust Act relied upon the appellant defendants. Said section does not cover a suit of the present type. Analogy has been drawn of section 92 of the Code of Civil Procedure while considering section 50 of the Bombay Public Trust Act. Both provisions are in the nature of representative suits which pertain to public trust and protection of public interest in the trust. In the present case, there is no public interest involved. The only interest is that of the plaintiffs and their families. The right of Archakship is claimed on the basis of inheritance. It is a hereditary personal right which they want to establish. The right is purely of a private nature. We are of the view that section 50 of the Public Trust Act is not attractive at all in the facts of the present case. We have seen the object of the Bombay Public Trust Act. Appropriately, the Act seeks to regulate and make better provision for the administration of public, religious and charitable trusts. Such trusts cater to things of public interest, things which concern large sections of the public. Unless such trusts are properly administered, public interest will suffer. Therefore, matters affecting administration of such trusts are covered under section 50 of the Bombay Public Trust Act. Situations somewhat similar to suits under 92 of the Civil Procedure Code. These suits are suits in representative capacity and pertain to matters of public interest. In contrast, a suit which has given rise to the present appeal is a suit to establish an individual right. Plaintiffs claim that they are hereditary Archaks of the temple since time immemorial and are entitled to exercise this right which cannot be taken away from them. No public interest is involved. Public is not concerned whether A acts as Archak or B acts. Such a suit, therefore, is not covered by section 50.
But there it's for an individual.
Yes. Whether it is an individual or a company involved, the right that is claimed or not is the question. Whether it is a right which is personal to me now, for instance, or it is a right which is enlarged that the entire public is involved, that there may be some public interest involved.
No, what you are saying is these lines could be important. Both the provisions are in the nature of
representatives,
which pertains to the public trust and protection of public interest in the trust.
In the trust.
Here there is what, according to it, we have understood. The action which you are taking, the filing of the suit, is not prejudicial to the trust.
No.
It's something which is in the interest of the trust, seeking protection of that license which you have. Maybe in the trademark.
Yes.
That's
yes.
What, in the trust. So to that extent, there is nothing which is to the prejudice of the trust. As such, the suit is maintainable and no permission is required to be taken. Is it your matter?
No, my case is, insofar as I am concerned, there is a private contract between two parties. One is the public trust, and this is an entity which we have. That is the plaintiff. That contract is of a private nature. That contract is of a private nature where I have.
Which is the trust here?
The trust is them.
Trust is there.
Them. They are the trust. We are not a company. Therefore, they are the trust, and they are the ones who are violating it. They violated the contract, therefore we terminated this contract. Therefore, they derived not the right because of me. I gave them the right by a license. Now I've cancelled the license. Now that cancellation cannot have a representative character or cannot be in the public interest of the trust. Maybe my Lord, trust may suffer. It is like saying, my Lord, I give a property on lease. Tomorrow the trust says, but my office is there, but I've cancelled the lease. You cannot say, now go to the charity commissioner, get permission from him, then come. But please take it. It works both ways in this case. Tomorrow, if the public trust wants to sue, also they must go. Because the charity commissioner's permission is for both sue and to be sued. Suppose someone interferes in their possession of a property. Should the public trust then go to the charity commissioner, make an application, spend 6 months, because 6 months is the time to grant permission, spend 6 months, get his consent, then go and file a civil suit? Can't be it. Therefore, that private right which you are seeking to enforce is a right not which you have, personal to someone else. It is not, if suppose not a whole bunch of trustees act contrary to the interests of the trust and start, let's say, frittering away the properties of the trust. 2 members of the trust or a person who may not be part of the trust but has an interest in the trust can then, because it uses the expression 2 or more members, can then go apply to the charity commissioner, file the entire complaint as to why as a matter of in Karnataka, we have a practice of filing a miscellaneous petition for permission, and the plaint is enclosed to the miscellaneous petition to highlight what are the issues. The court then examines it and then says, I will give you permission to sue. Then the plaint which is enclosed to the miscellaneous application becomes an original suit, and then we proceed.
Before the same authority.
No. In Karnataka, when we file a suit under section 92, if your lordships look at section 92 of the Civil Procedure Code, all suits against public trusts are to be filed under 92.
Right. Okay, the permission which is.
But for that, I need permission of the court or my lord of the Advocate General.
Then proceed.
And then proceed. Which is why we enclose the plaint as a document to the application and request permission. Of course, when it's different.
To be registered as a miscellaneous.
Miscellaneous.
And thereafter, an order will be passed.
Order will be passed. Of course, it's
To examine whether there is a inter se administration of the trustee is involved or not.
correct.
And then
Many a times, when trustees claiming rights will file a suit under section 92. That can't be done because whether their rights are personal is a different issue. A trustee has been removed. That will not become the administration of the trust. The trustee will file a separate suit saying you've removed me wrongly. That will not be a section 92 suit. That will be a simple suit. But that should relate to the administration of the trust.
But Mr. Chinappa, if ultimately you succeed in your declaration and whatever, will not be the trust gets affected.
Trust will get affected. In every case, my lord, where someone is claiming a right, another entity will get affected. That is going to be the context of every agreement that the trust signs. Tomorrow, my lord, trust says, I'm taking a property on lease and I'm on that property. The property is then terminated by the landlord. The lease is terminated by the landlord. And they say, I'll take possession. And I go through a process of court. Trust will be affected. But that is not a right which is protected by section 50. Which is why Supreme Court says it has to be something more. It has to be representative in character. The suit which you intend to file or the proceeding which you intend to file has to be representative, which is why the first option is given to Charity Commissioner. Under section 50, the Charity Commissioner himself can sue. So he takes over, my lord, practically and says, I will sue. Or I will give consent to two or more persons to sue. Therefore, which is why section 50 provides for, my lord, that scenario.
Now you say that in any case, for any
Yes.
declaration or injunction in
Yes.
favor or against a public trust or a trustee or trustees
Correct.
or beneficiary, the Charity Commissioner, after making such inquiry,
Beg your pardon?
then this 4 would come in.
4 would come in. Now, 4, which is the argument they're trying to advance, my lord, saying 4 would come in any declaration or injunction that you see. Please see, in favor of or against the public trust. Therefore, whether a public trust makes the claim or it is against the public trust, everyone has to go to the Charity Commissioner. So the argument on the basis of 54 is that any declaration is covered, which is why, my lord, the context in which the law has been made has been analyzed by the Supreme Court, saying it all has to be of a representative character. My lord, a declaration, if I may just say this, a declaration that the public trust is acting contrary to the objects of the trust.
Now if you see, how would you see P? The
Yes.
later part of it.
My lord, it is this part. The first part is what kind of suits.
Yes.
The second part is what reliefs. So the second part of it, in my humble submission, will depend on how your lordships interpret the first part of it. The first part of it is where your lordships will find the subject of the suit has to be examined, because your lordships will find whether the breach of public trust, recovery of possession or following of property, directions necessary for administration of public trust.
Any case.
Yes, yes.
Or any declaration.
In any,
That would be the subject matter of the suit.
for any declaration or injunction in favor of or against the public trust. This, my lord, which is why I'm saying, how 50 has evolved has been explained in para 14 of the judgment of the Supreme Court.
Yes.
Saying the object. We have seen the object of the Bombay Public Trusts Act. Appropriately, the Act seeks to regulate and make better provision for the administration of public, religious and charitable trusts Such trusts cater to things of public interest, things which concern larger sections of the public. Unless such trusts are properly administered, public trust interest will suffer. Therefore, matters affecting administration of such trusts are covered under Section 50 of the Public Trusts Act. The situation is somewhat similar to suits under 92 of the Civil Procedure Code. These suits are suits in representative capacity and pertains to matters of public interest.
One more time. And then you see next one. Where's the personal interest there? I saw it.
Yes.
Lordship may see the next judgment at page 75. This was Baroda Cricket Association. Page 75.
Yeah.
Yes.
Page 75, my lord. Baroda Cricket Association is a society and is also registered as a trust under the Bombay Trust Act. This was in relation to members who were elected to manage the society, secretary and other members. Your lordship will find it at para 3, page 76. Appellant is original plaintiff. Defendant number 1 is Baroda Cricket Association. Defendant 2 is the president. As averred by the plaintiff, he is closely associated with running of BCA. Time to time, he is co-opted as secretary. Election for different elected posts is completed. And he files note at the bottom of the page. Plaintiff therefore filed regular civil suit number 356, Vadodara, and prayed for a declaration. And this prayer is the prayer for declaration. Defendants had no authority to prevent the plaintiff from discharging his duties as secretary to BCA. And they had any authority to remove him from such position. Again prayed for declaration that decision of the managing committee to remove him from the position of secretary is illegal. He prayed for permanent injunction preventing him from discharging his duties as secretary. Therefore, although this was specifically with respect to his right, it directly impinges upon the administration of the entire society and the trust. Lordship will find at para 4 in the middle, the fact that it is registered as a trust under the Bombay Trust Act, para 4. And the argument on the other side was until the requirements of section 50 and 51 are satisfied, he cannot sue. Then a large number of judgments are examined, and then at para 88. I'm sorry, page 88, para 13.
Are you saying saying it is only if there is a issue regarding administration of the trust.
Ultimately, not even if it's a declaration has to be in respect of a declaration of the kind saying that the trust is not being administered properly. All of them are justum generis. It all relates to the administration of the trust. If it is read otherwise, it is disastrous. Because not even for them to sue someone who is interfering with the property, they'll have to go to the charity commissioner, wait for 6 months and get permission.
Yes.
Para 13. Entire suit thus was for the purpose of enforcing the plaintiff's personal right. It had no element of any interest of the public trust. In plain terms, plaintiff asserted a civil right to continue to hold an elected post till the term was over, till it was legally and validly removed. His suit and the ultimate reliefs had no connection with the administration of the public trust. It may also be that if any two or more beneficiaries under the trust had also found it necessary to challenge such a decision of the managing committee having any element of administration of the public trust, they, after making out such a case, should have applied to charity commissioner for his consent in writing. This is, however, not the same thing as suggest that even when the plaintiff questions such a decision before the civil court, it necessarily had an element of administration of the trust. This would be for two reasons. Challenged by any of the beneficiaries if they find that the removal of secretary had any effect on the administration of trust, and the grievance of the secretary to his removal, and his assertion of his own personal and civil right to continue to hold the said position till the term was over would not be mutually exclusive. Secondly, if the plaintiff's rights were to examine only within the parameter of section 50, such right can only be asserted by beneficiaries who must be minimum 2 in number. In other words, therefore, the plaintiff would have no individual or independent right to question a decision palpably adverse to him. This would leave the plaintiff without any remedy whatsoever. An interpretation court would, as far as possible, avoid. Which one?
Page 59. Relevant paragraph starts at page 54.
Then one judgment directly which answers, I think, this better is at page 59. At 62, my lord.
Yes.
Para 7. Present suit has been filed for a declaration of the plaintiff's title over the suit property against the trust. And for a perpetual injunction, section 54 would come into play when an injunction is sought against the public trust. Sanction of charity commissioner for institution of a suit for the aforesaid release is required only if it is filed by a person having an interest. The suit must be instituted for relief stipulated under 50. These reliefs mainly relate to the working of the trust and its trustees. Therefore, permission of the charity commissioner would be required when a suit is instituted by a person having interest for a decree in terms of the reliefs delineated in section 50. The submission of the learned counsel applicant, the sanction of the charity commissioner is required since the suit is filed for a declaration injunction is without merit. Declaration injunction sought by the plaintiff relate to his contention about his title to the suit property. Apart from this, the plaintiff is not a person having interest as defined under section 210 of the Act. Therefore, the requirement not is I should have an interest in the trust and I should espouse a right which is a public right. And therefore, those four requirements in 50 are really requirements which relate to the administration of the trust. If I claim a private right, which is, there could be hundreds of rights, hundreds of contracts that they may enter into. Tomorrow, my lord, they may have a contract where they license software which they develop. They'll turn around and say, no, you can't ask for an injunction, or you can't stop me from using the software. Or they may take software, like for instance, if tomorrow they really to take it to an extreme, their computers may be working on Windows and they may be using a pirated copy. Or they may have a contract with Windows to use it and the term expires. They sue on the contract saying your term is expired, you can't use Windows. They say, no, don't come here. Please go to the charity commissioner, get his consent. If he gives you consent, then you file a suit. That will not result in a scenario where you will practically insulate a public trust from any suit until the charity commissioner decides. That, in my respectful submission, neither the object of the Act nor because section 52 says they are all relatable to 92 and 93 of the Civil Procedure Code. Therefore, 92 and 93 are kept out and this provision is implemented. Otherwise, your lordship will have a situation where every suit will have to go necessarily to the charity commissioner first, his consent, and only then you can proceed. Then of course, I will not read all the other judgments. The number of judgments which have said an application of this kind cannot be for rejection of plaint. You can't make an application on this ground for rejection of the plaint because it is a matter of evidence and trial has to happen, and that has to be determined as to whether it relates to administration. But in my respectful submission here, it is nobody's case that I'm interfering in the administration or that I'm seeking some relief with respect to administration of the trust. My relief is simple.
This has to be decided by way of an issue.
It could be, my lord, but in my humble submission now, on the basis of the law that is now there, it is fairly apparent that the right I'm claiming is only under the contract. And therefore, the question of going to the charity commission can never arise.
Not related to administration of the trust.
Not related. Suppose, my lord, I'm suing under I asked for an injunction as the registered trademark holder. If I file a suit for injunction, can they turn around and say, no, you, for that also you must go to the charity commission because you're asking for an injunction against me. You'll stop me. I will not be able to function anymore as a trust in that name. I will not be able to utilize that name. Therefore, go to the charity commissioner first, only then come and file a suit. Respectfully, therefore, there has to be a difference in the language used in section 50 insofar as those reliefs are concerned, or that nature of suit is concerned, and the ultimate relief that can be granted by a court. Which is why, my lord, in my respectful submission, section 50 has absolutely no application in this case. The mistake that the learned judge did is thinking it's an institutional right that I, as a company, am espousing against them. But my right against them is personal to us. No one else can make a claim with respect to that right. Therefore, the question of saying you are now asking for something more in my humble submission can't arise. It is almost like saying, oh, you stop them, the poor trust may not be able to use IEEE. But that's too bad. You've entered into a contract, signed the agreement, and that's the end of it. That's the first one. This second argument, no. 20 minutes is a long 20 minutes. I'm sorry, it's a long 20 minutes.
How much longer?
5-10 minutes.
Let's see, we take a chance tomorrow, then we'll see. Tomorrow.
I'll take another 5 minutes on the second point.
You say that Mr.
Great.
Great.
Permission may not. 59 not. Seeking complaint appointment may not. Single director the appeal may not to appoint R may not.
Which number? Which
serial number 59 may not.
Not required.
The director may not to more than 2 years may not. They are not complied.
Contempt.
59 serial number. Appointment of compulsion ground.
What is the date given? We'll give you date.
Yes, the start date, madam.
Just give a minute. In this matter, you can give a date. Just come back and tell me.
Court officer, court officer.
ಸರ್ ಹೇಳಿ ನಾಗರಾಜ್ ಸರ್ ಹೇಳಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಹೇಳಿ ಸರ್
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 101 ಏನಾಯ್ತು ಮೇಡಮ್
ಅರ್ಜೆಂಟ್ ಸರ್
ಏನ್ ಡೇಟ್ ಮೇಡಮ್
ಕಾಲ್ ಆಗಿಲ್ಲ ಸರ್ ಅದು ಅರ್ಜೆಂಟ್ ಅಷ್ಟೇ
ಆಯ್ತು ಮೇಡಮ್ ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್
Madam, 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 madam.
ಸರ್ ಹೇಳಿ ಹೇಳಿ.
ಹೌದು ಮೇಡಮ್ 21 ಯಾವಾಗ? ಮೇಡಮ್ 21 ಯಾವಾಗ? ಮೇಡಮ್
ಸರ್ ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ 21 ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 112 ಏನಾಯ್ತು ಮೇಡಮ್? ಸಡನ್ ಆಗಿ ಕೊಲಾಪ್ಸ್.
ಕಾಲ್ ಔಟ್ ಆಗಿಲ್ಲ ಸರ್. ಅರ್ಜೆಂಟ್.
ಡೇಟ್ ಏನಾದ್ರು ಕೊಟ್ರಾ ಮೇಡಮ್?
ಡೇಟ್ ಕೊಡ್ತೀವಿ ಸರ್.
ಓಕೆ
ಡೇಟ್
ಮೇಡಮ್.
ಆಮೇಲೆ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್,
ಥ್ಯಾಂಕ್ ಯು
ಹೇಳಿ
ಮೇಡಮ್. ಥ್ಯಾಂಕ್
ಹೇಳಿ.
ಯು.
112 ಏನೋ ಡೇಟ್ ಕೊಟ್ರ ಮೇಡಮ್?
ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಮೇಡಮ್. ಆಮೇಲೆ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಕಾಲ್ ಔಟ್ ಆಗಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಕಾಲ್ ಆಗಿಲ್ಲ.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
Court officer.
ಹೇಳಿ ಸರ್ ಬೇಕಾ?
ಸೀರಿಯಲ್ ನಂಬರ್ 65 ಡೇಟ್ ಏನಾದ್ರು ಕೊಡ್ತೀರಾ ಇಲ್ಲ?
ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಸರ್.
ಒಳ್ಳೆ ದಿನ ನೋಡಿ.
28/7.
ಎಲ್ಲ ಪಾರ್ಟಿಗಳು ಅಷ್ಟೇ
ಕಾಲ್ ಔಟ್ ಆಗಿಲ್ಲ ಸರ್. ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಕೊಡ್ತೀವಿ. ಜಸ್ಟ್ ವೇಟ್.
ಬೆಳಿಗ್ಗೆಯಿಂದ ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಆಗ್ಬೇಕು ಪಾರ್ಟಿಗಳು?
Court officer.
Sir, namaste, sir. Sir, ಬರ್ತಾರೆ, sir. 5 minutes. Okay, sir.